Hello and welcome back to the Karen retrial isn't over, so we have to continue to talk about it. My name is Lily, and I am the Chatty Juror, and jurors themselves are being chatty as well. This is so exciting. I mean, not in like it's good for many things because it's going to make this entire process that much more difficult to get through. So we have to talk about all of the things. What's happening? I have new things and they're not being nice to me. Okay, that's better. Did it just fix itself? I think it did. I think it did fix itself. No. I feel like I touched something. Okay. So we have a lot of things to go over, and I think we're going to do a lot of rewatching of things as well. Let me get in here and just make sure everything else. Do. Okay. All right, so I'm going to the I don't even know where to start with all of this. So everything started with a motion to dismiss coming from the defense, obviously, because they don't want or seem it reasonable to have another trial for some reasons that we will go over. So this is the defendant Karen Reed's motion to dismiss, and I'll give it a read. I'll give it a read. It's not that easy to see. It's only a couple of pages, and it gives a really. I don't want to say it gives a really good background because it gives a background of some things that are happening a few days ago. We're going to work our way up to present times. We are going to work our way up to present times. So the defendant, Karen Reed's motion to dismiss, now comes, maybe if I just Now comes the defendant, Karen Reed, by and through undersigned counsel, and hereby moves this honorable court, pursuant of the 5th, 6th, and 14th Amendments to the United States Constitution and Article 12 of the Massachusetts Declaration of Rights, to dismiss counts 1 and 3 currently pending against her on the grounds that the jury reached a unanimous decision to acquit her on those charges, and alternatively, because there was no manifest necessity supporting the declaration of a mistrial with respect to the charges on which the jury had agreed that Miss Reed was not guilty, and that therefore a retrial is on such counts would violate the double jeopardy protections of both federal and state constitutions. So this in itself is absolutely wild to hear that from something that was declared a mistrial, because there was no unanimous decision made by the jury. So Judge Bev, who people aren't very happy with, uh, who support Karen Reed, declared it a mistrial due to the jury coming back for the third time without making a unanimous decision, without filling out the verdict slip. So mistrial. So why is this paragraph even in existence? Why are they saying that there was a unanimous decision? Well, if we keep reading, we will find out. The ancient right to a jury trial is no more procedural formality, but rather a fundamental reservation of power to the American people. uh, by requiring the executive branch to prove its charge to a unanimous jury beyond a reasonable doubt, the Fifth and Sixth Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of pretended offenses and arbitrary convictions. So we have the declaration for why. And let's continue to the next. And I'm just going to skip over the citations. Prominent among the reasons colonists cited the Declaration of Independence for their break with Great Britain was the fact Parliament and the Crown had deprived them in many cases of the benefits of trial by jury. After securing their independence, the founding generation sought to ensure what happened before would not happen again. As John Adams put it, the founders saw representative government and trial by jury as the heart and lungs of liberty. It follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. The double jeopardy clause provides that no person shall be subject for the same offense to be twice put in jeopardy of life or limb. The clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, thereby subjecting her to embarrassment, expense, and ordeal, and compelling her to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty. Perhaps the most fundamental rule in the history of double jeopardy jurisprudence has been that a verdict of acquittal could not be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution. It's lawyer long-windedness of here's all the things of why it's naughty if we do it again. Here's all the things of it being a no-no if we have to do all this again. And they're going to get to why and the because soon. Here, the very day after a mistrial was declared, undersigned counsel began receiving unsolicited communications from 3 of the 12 deliberating jurors, indicating in no uncertain terms that the jury had a firm 12-0 agreement that Miss Reed was not guilty of 2 of the 3 charges against her, including the charge of murder in the second degree. So when they say, when they say 3, let's just put like let's just say it was actually one with 2 sort ofs. I have so many questions. Hey Ray, what's going on? And we're gonna get to it, but we have to start from the beginning of all the things that happened, and then we'll work our way up to current day for it all. So I'll try to cover every little thing that has happened because there's so much that has happened. Given the central importance that acquittals have held in their criminal justice system for hundreds of years, let me boot scoot boogie to page 3. The defense respectfully submits that the jury's unanimous agreement precludes re-prosecution of Miss Reed on counts 1 and 3 and mandates dismissal of those charges. So, hey, the jury members are telling us they were unanimous. This mistrial was a joke. Counts 1 and 3, she cannot be retried on. They were unanimous, not guilty. Alternatively, the extent the court believes further factual development is required, the defense respectfully requests that a post-verdict inquiry be held on the issue and that the court authorize defense counsel to seek additional proof from the jurors regarding their having unanimously acquitted the defendant of 2 of the 3 charges against her prior to indicating to the court that they could not reach a verdict on the 3rd charge alone. So they're like, hey, can we meet up with these jurors? Can we get a meeting? Can we get our own little, in-person group chat going? Because they have questions, the jurors have questions, and everyone needs answers before the next trial begins. Because the answers that the jury gives, the answers that will come from the end of this whole situation will dictate if there is even a next trial, if what charges the next trial will include, if any. So background. On June 9th, 2022, Ms. Reed was charged via 3 separate indictments with murder in violation of MGL, vehicular manslaughter in violation of MGL, and leaving the scene of personal injury or death in violation of MGL. A jury trial began on April 16th, 2024. On June 25th, 2024, the jury began deliberations. Yes, April 16th, and the jury was handed it June 25th. Oh, that was a long couple of weeks. On July 1st, 2024, when the jury presented a note to the court, all counsel were ordered to the courtroom. Um, Note to see Alan Jackson's affidavit. The note was not presented to counsel for review. We're going to watch it. We'll go back over it. We'll see what was happening. We'll we'll have our fresh eyeballs on it, and we'll see how it felt, what happened, what could have happened, what should have happened, um, and we'll look at it in a completely different light. Um, Rather, the court indicated that the jury was at an impasse. They probably could have quoted that because, or subquoted it because jury's at an impasse was is exactly what she said. And then she said, "Bring the jury. We're done." Once the jury was seated, the court then read the jury note verbatim in open court, and without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. Yes and no. I'm going I'm gonna say yes and no. Yes, that is the chain of events. But the details in between, uh, maybe not so much. Like maybe not so much. CID 81. While the juror's note, as read by this honorable court, indicated the impasse was on charges, it did not say whether the charges were those within count two, i.e., the multiple ways to find guilt on count two, or extended to other counts. So the affidavits attached here and indicate the former, not the latter. We'll talk a little bit more about it when we watch it. In short, neither the defense counsel nor the defendant consented to the mistrial. Thank you so much, Reddit, for having these up. And the court never ascertained from the jury whether its deadlock was in relation to one, two, or all of the charges in the indictments. The jury was never polled. So at the end of a case, when there is a unanimous decision and mistrials, sometimes in open court, sometimes not for mistrials, it is a discussion, a polling of, where did we stand? How many? What's happening? Show me the numbers. Now, the polling does not go into the activities in the jury room, in the deliberation room. It doesn't go into how the deliberations were happening. What were you guys talking about? What were you guys unsure about? It doesn't go into any of that detail. It's just where do we stand at this point? How are we split? Or if there is a unanimous decision of either guilty or not guilty, polling of the jury says, um, is this your decision? Is this yours? Is this yours? Yes, 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 yes. And there have been times where guilty or not guilty has been declared, and they poll the jury, and a juror member says, no, nope, nope, that's not me. That's not the decision I made. That's not what we talked about back there. So things like that can happen, not very often. So the following day, on July 2nd, 2024, Attorney Jackson was contacted by a juror in this matter, Juror A, they are calling them, who stated that she or he wished to inform him of the true results of the jury's deliberations. ID 4. Okay, we'll find it. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty of count 1, second-degree murder. Juror A was emphatic that count 1, second-degree murder, was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. The jury also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene with injury/death. Another day later, on July 3rd, 2024, Attorney Yannetti was contacted by two different individuals. Bear with me, keep up. If you want me to reread anything, we totally can, because this is when things get a little bit tough to sort of digest. So another day later, on July 3rd, 2024, Attorney Yannetti was contacted by two different individuals, hereinafter Informant B and Informant C. They are not labeled Juror B and Juror C because they are informants. They are not the jurors, who had received information from two distinct jurors, hereinafter Juror B and Juror C, both of whom were part of the deliberating jury in this case. David R. Yannetti, affidavit, paragraph 2. Informant B sent Attorney Yannetti a screenshot he or she had received from someone, hereinafter intermediary B, of text messages that intermediary B had received from Juror B. In that screenshot, I mean, come on. Informant B received a text message from intermediary B. Informant B sent a it's all the down the line. Down the line. So it's not a direct communication from the juror to Yannetti. In that screenshot, Juror B texted the following information to intermediary B. It was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. That's a weird one. Screenshots don't lie unless you're a prosecution witness. Yeah. And in that same vein of thought, if the DA expected the jury to take a screenshot of a phone without any metadata as serious, informative evidence, then why would that energy not apply to this as well? That a screenshot with what possibly does have metadata. I'm sure that information is probably, stored and was stored quite swiftly, by these good attorneys, in my opinion. That same energy should be supported for this screenshot as well. We were handed screenshots in the trial that had nothing, no substance, not worthy of being there. It could have been from anyone. It very easily could have been altered. It didn't mean anything, but they expected the jury to take it as truth. So the defense is playing that same game, in my opinion. They felt strong enough on it to not just move forward with one juror came out and spoke to us. They did not have to add this into their initial motion to dismiss. They did not have to, but they did. They added it, because they felt that it was prudent to do so, and just is more in support of things were totally effed up. There's so much. We have so much to talk about. This is gonna be so fun. Okay, so it was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. I don't know what that's supposed to mean. That could be a few different things, like no one thought she hit him, or even thought she hit him on purpose. That's kind of the vein that I'm getting. It might have been just like a mistype, but I'm sticking with the quote in this motion. Informant C had been in contact with another individual, intermediary C, who was a coworker and friend of Juror C, and joined a Zoom meeting during which Juror C discussed the trial. So Juror C was like, y'all are never going to believe where I've been for the last 7 weeks. I was a juror on the Karen Reed case. I'm going to need y'all to hop on a Zoom super quick because we have to spill the tea. I'm sure people were like, we know you were a juror. Like, you can't just disappear for that long. Like, we know what's going on. Tell us everything. And they were like, sure, let's get a Zoom going. Let's have a glass of wine probably and chit chat. Or Bud Light and Canton. honor. Informant C. Okay, so let me just read that one more time so everyone. Informant C had been in contact with another individual who we call intermediary C, who is a co-worker and friend of Juror C, and joined a Zoom meeting during which Juror C discussed the trial, which they have all right to do. There's nothing like incorrect about that at all. They have all right to do that. The trial is over. A mistrial was declared. They can talk about the case to anyone that they want. The jury can talk to anyone that they want. They don't have to talk to anyone if they don't want to. And right now, the jury list has been impounded, which in Massachusetts is the word that they use, which just means sealed. And so the media will not be able to reach out to jurors. They can reach out to the media. They can if they want to, but they don't have to. There's no more requirement from the jury unless they are called to appear in court again to get pulled and talked to and questioned. Not in a you did anything wrong type of way, but let's get some more information type of way. Informant C sent attorney Yannetti the below screenshots of his/her text messages with intermediary C regarding what juror C revealed in the Zoom meeting. So this isn't even like she told me, it's someone, she told me and juror C told her. It's crazy. All right, so intermediary C, no consideration for murder to manslaughter. Let me go to the next page. Zoop, 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 zoop. Manslaughter started polling at 6-6, then ended deadlock at 4 no, 8 yes. Informant C, interesting. If it was no consideration for murder too, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict slip that was all confusing. She should have been acquitted, I agree. Yes, the remaining charges were what they were hung on. The remaining charges were what they were hung on. And that instruction paper was very confusing. And this goes to jurors being lay people. Like, jurors are just people. Jurors are not attorneys. Jurors do not have law degrees. Jurors do not have some strange obsession with the law and read things probably more than the average bear. Jurors don't know legalese. I love how the judge never told us they were hung on one count. Well, because the judge herself didn't know. The judge herself didn't know, in my opinion. So when we go back, we're gonna go watch the jury instructions. We're gonna go watch the we're gonna watch the jury instructions. We're gonna watch her reading each the last note. We'll watch her reading the whole process of getting the last note. And we will talk about what we all think when it comes to the words that were in the note. Oh, good. She confused the jury and herself. Yeah. Yeah. Well, so the issue with it was the jury in the note said, you cannot come to like a unanimous decision on these charges, right? There was no indication unless she did not read something on the note, which I'm pretty sure would have already come out the moment it entered. Jury notes go into evidence for the case. So they continue to, the last pieces of evidence for the case are the very last things that happen. The jury notes, the verdict slips, and all that stuff. So that's entered as evidence in the case, and that is all visible to the attorneys. So if the attorney saw that the judge didn't read that, we're unanimous on this, but we're hung on this, or some sort of wording to that effect, she was given a note that says we cannot come to a conclusion on these charges. Now, if that is pertaining to all three, count one, count two, count three, or if it's the, coming to a conclusion on the charges within count two, because there's the undersigned little extra bits as well. So that's where the issue is coming in, and that was made mention, I think, on like page 2 or page 3 or something of this motion, that there's I can actually go back to the note. I'll find it. What did they mean when they said charges? So right down here, it says, while the juror's note, as read by this honorable court, indicated the impasse was on charges, it did not say whether the charges were those within count two, i.e. the multiple ways to find guilt on count two, or extended to other counts. So the affidavits, the next ones that we go over, we'll talk all about that. So was it count two specifically and all the things underneath that they were having an issue with, or was it count one, count two, and count three that they could not become unanimous on? This is why it's kind of like, this is why it's so weird. Well, first of all, this whole thing is so weird. This whole thing is so weird. And is rare. And could set a pretty interesting precedent. And we are going to, I'll pull up the verdict slip as well, and we'll talk about how confusing is the verdict slip actually. How confusing is it actually? Okay, so 2, argument. The jury's unanimous conclusion that oh good, she confused the jury and herself. Yeah, I think, okay. She made mention a few times of how tired she was. So I think the chances of her confusing the jury, like the more tired you are, the more like confusing, like your thoughts aren't going to be in a straight line. I mean, for me, my thoughts never are, but they're decipherable. And I think that she had a higher opportunity to confuse herself as well, with how exhausted she was, like physically and psychologically, from this case. She has to sit there and rule on all of the things, and sitting there as an experienced attorney, as an experienced judge, and seeing all of this just insanity play out in front of her. She can't object herself. She can only rule on the objections given to her. So she was seeing all of the ridiculousness as well. And I'm sure that as the trial was continuing on, she was seeing all of the ways that her job is going to get more difficult. She's seeing all of the ways that more and more things like this are going to happen. And not like this, like this motion to dismiss, but Proctor being fired, so-and-so doing this, and so-and-so getting found out on this. And, like she's seeing that there's a lot happening. And the rug has been lifted to it all. Like, so everything has been swept under it, and it is slowly being lifted and uncovered for all of the things. So she's seeing this as well. So I'm sure that there was stuff happening. There was stuff happening inside her brain that probably led to her confusing more people than she normally does in her courtroom. The jury's unanimous conclusion that Miss Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes re-prosecution. So what constitutes an acquittal is not to be controlled by the form of the action in question. Rather, the court must determine whether the action actually represents a resolution, correct or not, of some or all of the factual elements of the offense charged. The mere presence or absence of check marks on a form is not dispositive. The citation is omitted, but we're not going to go over the citations. We're not legal experts. We're just folks who read and chat and think with our common brain sense. Here, the attached affidavits by attorneys Jackson and Yannetti reflect statements by 3 deliberating jurors, that the jury had reached a final unanimous conclusion that Miss Reed was not guilty on counts 1 and 3. So you have to ask the question, why didn't they just put a check mark next to not guilty for those counts? Right? Why didn't they say, "Oh, we have, not guilty, and can't decide," and handed that in? We'll talk about that, of course. There was nothing tentative about the jurors' statements. To the contrary, they were definitive in describing the result of the jury's deliberations. Juror A was emphatic that count 1, second-degree murder, was off the table. And there we go. And that all 12 of the jurors were in agreement that she was not guilty of such crime. Reflecting text message from juror B, it was not guilty on second degree. No one thought she hit him on purpose or even thought she hit him on purpose. um, Reflecting juror C's statement relayed by intermediary C that there was no consideration for murder too, and Miss Reed should have been acquitted on that count. To hold that this firm conclusion did not amount to an acquittal simply because it was not recorded in a verdict form, verdict slip is what they like to say in Massachusetts, would be to elevate form over substance in a manner prohibited by the foregoing United States Supreme Court and Supreme Judicial Court precedents. The Supreme Court's decision in Bluford is not to the contrary. There, a juror had reported during deliberations that the jury was unanimous against the charges of capital murder and first-degree murder, but split on manslaughter. The court sent the jury back to continue deliberations, and when the jury remained unable to reach a verdict, declared a mistrial. The Supreme Court rejected the defendant's argument that the double jeopardy clause prohibited reprosecution for capital and first-degree murder. In doing so, the court relied heavily upon the lack of finality of the jurors' report. The jurors' deliberations had not yet concluded, and it went back to the jury room to deliberate further. Here, by contrast, the jurors' statements reflect a final determination that persisted through the end of deliberations. Even assuming arguendo, and contrary to the foregoing, this court finds that retrial would not be prohibited under Bluford. This court can and should afford broader protection under Massachusetts state law. Unlike the United States Constitution, the Massachusetts Declaration of Rights does not include a double jeopardy clause, but our statutory and common law have long embraced the same principles and protections, which is interesting. That's very interesting to me. Like they can and could, but they don't, type of deal. Let's see here. Re-prosecution is independently barred because there was no manifest necessity to declare a mistrial on counts on which the jury was unanimously agreed. The double jeopardy clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal. I'll just say her because it's her. Thus, where a mistrial is entered without the defendant's request or consent, retrial is impermissible unless there was a manifest necessity for the mistrial. Here, Miss Reed did not consent to the declaration of a mistrial, rejecting argument that the defendant consented to the declaration of a mistrial because he did not object when the judge ordered the case dismissed. Very interesting, sort of getting ahead of themselves there, because there was a moment in time when this final letter was being read for them to use their voice. It is not wrong for a lawyer waiting for a jury to come in, knowing the next steps to say, are you going to call a mistrial? Like, what are we doing next? We were told they're at an impasse. What's the next steps before we get to a mistrial? What, is they could have spoken up, but they didn't. There's reasons why, I'm sure. You don't know what the impasse is. You don't know if they're 11-1 not guilty or 11-1 guilty. Speaking up could quite possibly have not the ending that you wanted for your client. So lots of options there. Lots of things, lots of unknowns, and they didn't speak up because they didn't know how they were hung. They didn't know. So, but we'll see. We'll watch it and we'll see how you guys feel. Um, Okay, absent the defendant's consent. I mean, state and federal double jeopardy protections bar, as a general rule, retrial of a defendant whose initial trial ends without a conviction. This rule is rooted in the importance to the defendant of being able, once and for all, to conclude her confrontation with society through the verdict of a tribunal she might believe to be favorably disposed to her fate. A lot of people are watching this. If a retrial happens, which in my opinion, I don't think it will at this point, with what's happening with the jurors. If a retrial happens, where are they going to have it? They can't have it in Norfolk County. That's for damn sure. I don't think they could have it anywhere in Massachusetts. And what do you mean we're going to go into a completely different state? I don't know. Because you need an unbiased jury or a jury that can like pretend to be unbiased at the very least. And this community has become very outspoken about everything, every aspect of this case. So I don't know. I don't know how they're gonna find a jury for another trial, because that's crazy to me. Everyone was watching this. Everyone was not. This was and still is the main news headlines in these areas. Oh my gosh. I know my camera keeps glitching. I don't know why. I think I need a new thingy. I need a new thingamabob. I need a new thingamabob. You guys know what I mean. If they are in Albany, I hope you're called for jury duty, LOL. If I'm called for jury duty, I would immediately be sent out of the room. It's just over the state. It really is. It really is. Yeah, come to me, please. Let me be on the jury. Could you imagine? No, that would never happen. Because they'd ask me, I would try really hard. I would try really hard to be like, I'm completely unbiased, but something would slip and it would just be like, no, I am completely biased at this point. Because I watched the entirety of the first trial. I am in deep. Where were we? Okay, according to the heavy burden of establishing manifest necessity to justify a mistrial is exclusively on the Commonwealth. Hello. Like it's y'all's job to do that. Before a court declares a mistrial for manifest necessity, 1, counsel must have been given full opportunity to be heard, and 2, the trial judge must have given careful consideration to alternatives to a mistrial. And it did sort of feel like she was kind of almost ready. Sorry, no. You can interrupt. We're just reading this thing. You can interrupt. You're welcome to interrupt. Please always interrupt. Never not interrupt. Here, the defense respectfully submits that the lack of opportunity to be heard is alone dispositive. Upon receiving a jury note, the court declared, we're just kind of rehashing all of the things here. Upon receiving a jury note, the court declared a mistrial and excused the jury without consulting counsel. They really summed it down to very quick moments when there was, in fact, a little bit more space there. This action was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. I mean, no one silenced you. Finding no manifest necessity where no opportunity was given counsel to argue the propriety of the question or of the necessity of a mistrial. Ugh. Okay. Um Next, the record is independently lacking on the second prong as it reflects no careful consideration of alternatives to a mistrial. Here, there was one obvious alternative to simply ask the jury to specify the charges on which it was deadlocked. Okay, yeah, okay, let's talk about that. Let's talk about that. It was right before a holiday. They had been there for months. Even the judge wanted out of there, but that's my opinion. I definitely, yeah. So in it felt like she was ready to declare a mistrial super fast. Uh, it almost it almost felt like the second note she was like, "I don't want to call mistrial," and then um, the defense was like, "Tui Rodriguez, do that." Do that. Tell them that we spend a lot of money on this. Tell them that it's super important and that we really need them to try. Um, because the defense had a feeling that they were kind of hung in their favor. The Tui Rodriguez is basically just an instruction to be like, let's give it one more go. Let's give it one more go. You guys had a chance to sleep on it, and let's really come to a decision here. I, she, it almost felt like she had a battle inside of her heart and soul when the first note came back that they were hung, because it felt to me that they very much were like, okay, we're not guilty on the first one. She's not going to go to jail for the rest of her life for murder. Like, she can't. That's insane. um I don't know. I don't know, man. I don't know. It just felt so much. It just felt it went really fast. Like, it wasn't. Oh, we'll talk about it when we watch it. We'll talk about it when we watch it. um Asking the jury, let's talk about this. To simply ask the jury to specify the charges on which it was deadlocked is kind of crazy. In this situation, like that sentence is kind of wild to even suggest that the jury sitting there, yes, they're not on camera. We cannot see the jury. We do not know who the jurors are. But the town does. The folks in the courtroom are seeing them. There's not like a curtain in front of them. Um the as they called them, the McAlberts, the McCabe's and the Alberts and the Bryans and the Collins are there, and they the defense is saying that, oh, well, you kind of should have asked them like how they were hung. The jury just watched a trial of collusion and police cover-ups, like, of how these cops are bad and do bad things and aren't good and are naughty and break the rules, and they're going to sit there and say, oh yeah, no, I think Karen's not guilty in front of a police officer who knows your face and has a higher probability of finding your address. That's I would not be comfortable with that. That's a behind the scenes situation. That's in another room. That's where the no microphones are allowed situation. I don't. That feels like, okay, maybe in private, but not in front of everyone. Going back to these jurors coming forward really quick, do you think having two Alberts and Jen McCabe there staring them down had to play in how this is panning out? Yeah, I didn't even see this chat, but yes, the same wavelength. I definitely think it, w- it I think the shock and awe of looking at the McCabe's and the Alberts and the O'Keefes and Karen's family and their brothers and the siblings and the cousins and the reporters. I think the shock and awe would wear off fairly quickly. Um, the knowledge of this being a pretty high profile case is known. You're going to feel a little more comfortable every day doing your job, knowing that you have a job to do. um, from all of the reports that I've seen about the jurors, for the most part they were extremely awake, present. They were taking notes like nobody's business. They wanted to take in as much information as possible. They were there paying attention, you know, like us, we weren't pausing, they weren't pausing. They weren't taking, breaks to go get snacks when they wanted to. Like they were there and they were working hard. And I think they worked hard in the deliberation room too. Um, it might have affected some jurors more than others. More people, some people can be a little more sensitive to certain things, and stuff like that might have played a part in some people's decisions. But I think the intensity of them uh, wore off pretty quickly through the case. He was intimidating me, and I wasn't even in the room. He was eating into my soul. He was trying to, and I think that's a problem. And I think that's something that should have been addressed in the courtroom. That if I think it should have been mentioned to like the jury, like if you feel uncomfortable by any guest, by any civilian inside of this courtroom, please let us know and we will ask them to leave. You don't have to say it in open court. Send us a note, talk to the bailiff when you're on break or something like that. Um, I think that should have been a thing, especially when you are dealing with corrupt police officers at a higher level than your just local PD. You're dealing with corrupt, high level, highly trained, highly experienced veteran Boston police officers who made it to television. There was a show about one of the which Brian Albert was on TV, the fugitive something, I don't know, trash man, trash person. So that's yeah, I I think it might have. It could have. There's definitely an opportunity for that to happen, for sure. He definitely tried. He was trying to intimidate people. Yeah. But like the evidence is always going to have precedent over an ugly man's face. And the evidence is that you suck, bro. You're you're dumb. You're a dumb one. You're dumb. You're a dumb boy out here acting like a child. Um Had the court done so, asked the jury, and the jury articulated its verdict consistent with the statements of jurors A, B, and C, the double jeopardy implications would have been clear and decisive. Indeed, with virtual unanim the cases have applied collateral estoppel to bar the government from relitigating a question of fact that was determined in defendant's favor by a partial verdict. When the jury hands down a partial verdict, a final judgment is rendered on the counts upon which the jury has reached agreement. The Supreme Judicial Court's holding in Commonwealth v. Roth, etc., that courts should not request partial verdicts on lesser included offenses charged in a single count does not pertain here. As the Roth court acknowledged, they're sort of getting ahead of themselves with this one. They're like, we already know what Lely's going to come back with, so let's just cover it, which is basically what they're doing here. Blah, 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 verdicts on lesser included offenses that have not been separately charged carries a significant potential for coercion, declining to require courts to consider giving the jury new options for a verdict in the form of partial verdicts on lesser included offenses, where under Arkansas law, the jury's options were limited to two: either convict on one of the offenses or acquit on all. Such inquiry, in effect, implies that the jury should consider conviction on the lesser count. No similar danger is present, whereas here the jury was asked to return three separate verdicts on three separate counts. Distinguishing situation where a defendant has been charged in separate indictments or complaints, each with a separate verdict slip. In the circumstance where the jury reports a deadlock without specifying the counts on which it has reached an impasse, it is a straight. Where'd my camera go? Where'd my camera go? What is going on? Oh, El Gato. Why are you so hot? Oh, maybe that's playing a factor. Why my thing get so hot? Where's my mouse? God damn it. All right, we're fine. We know what we're doing. It feels like a Monday. It's not a Monday, but it feels like a Monday. Distinguishing situation where a defendant has been charged in separate indictments or complaints, each with a separate verdict slip. Did I already read that? Probably. In this circumstance, where the jury reports a deadlock without specifying the counts on which it has reached an impasse, it is a straightforward and the defense contends constitutionally required follow up to ask whether the deadlock relates to some as opposed to all counts. Okay, so they're laying down some road work that it's constitutionally necessitated that you ask how it was split. Where are we landing on the counts since there's multiple counts and you're calling it a debt? Like, where are we located here? How is this working? How is this ending? What's the stitch, folks? Spill the tea. Indeed, the Supreme Judicial Court has explicitly stated where a complaint or indictment in multiple counts charges multiple crimes, a general verdict could be returned as to one of the counts, despite deadlock on the other counts. Okay, so if that's true, why was that not made clear to the jury? And why did the jury not fill out the verdict slip saying not guilty? We don't know, not guilty. Count one, not guilty. Count two, I don't know. We're kind of stuck. Count three, not guilty. Why do we not have a verdict slip with not guilty? We're confused, not guilty. C. Alternatively, the defense is at least entitled to conduct post-verdict inquiry. Yes, undersigned counsel did not initiate the communication with jurors A, B, and C. Good, which resulted in a disclosure of information that is memorialized in counsel's affidavits that are appended to this motion. Should this court find that further factual development is required, the defense respectfully requests that the court conduct a voir dire of the jury and or an evidentiary hearing to substantiate the existence of an acquittal. Let's get together, let's meet up, and let's talk about it. Should the court seek the affidavit of each juror, i.e. jurors A, B, and C, the defendant asks for the court to authorize undersigned counsel to initiate contact for the sole purpose of asking each juror whether the jury had unanimously agreed that the defendant was not guilty of counts 1 and count 3. Were there any record of any verdict slips? Nope. Because they didn't fill anything out, because they were at an impasse. Because they had the confusion of but we're at an impasse. My camera, I am so sorry. I got a new thing to make sure my camera stays good, and it's freaking killing me, bruh. They were at an impasse, so they didn't fill out a verdict slip. And we'll get to why I believe they did when we listen to the jury instructions. Where were we? We're almost done with this. The judge has got to go. Here we go. The Supreme Judicial Court has held that because of the importance of the issue, juror bias is a legitimate subject for post-verdict inquiry. It is similarly a fundamental tenet of our system of justice that a defendant may not be retried for a crime on which she was previously acquitted by a jury, and the defense submits that the post-verdict inquiry is equally warranted in the present context. Just as the court in McCallop approved questions as to the existence of racial bias, questions about a matter more attenuated from the content of deliberations, whether the jury had unanimously concluded that Miss Reed was not guilty of counts 1 and 3, do not invade the heartland of jury deliberations, but preserve the defendant's precious rights to the favorable outcome of a jury trial and to the protections of the Double Jeopardy Clause and its related state judicial protections. So basically, we can ask them how they landed. We can ask them, were you then not guilty on count one? And were you then not guilty on count three? And were you then um, at an impasse for count two? It's not getting into how they deliberated. It's not getting into what food did you guys eat? How much money did you spend? Da, 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 da. How much time did you actually talk about this piece of evidence? It's not getting into any of that. They're saying because they know the rules, right? And they're like, but let me convince you that this is why we want to do this, and here's why. And it's not against the rules because we need to know, because like if it because if they say it was not guilty, confused, not guilty, then we have somewhere to be, like then we have some other things to fill out. We have other stuff to do, you know? You know what I'm saying? I love this so much. This is so much fun to me because I'm not a lawyer, and it's like so much, it's like common sense. And the way this motion was written, I think is absolutely fantastic. It's so digestible to a normal person. And I really appreciate that. It's digestible, it's ingestible. And the way that the wow, my brain stopped. The way that the Judge Bev was speaking and reading those instructions to the jury, it was indistinguishable from gibberish, in my opinion. Confusion, mass confusion. Okay, and in conclusion, for the foregoing reasons, Miss Reed respectfully requests that this honorable court, the sass, that this honorable court issue an order dismissing counts 1 and 3, respectfully submitted for the defendant, Karen Reed, by her attorneys. All right, so that is the very first thing that happened. The motion to dismiss. How are we feeling before we get into Mr. Jackson and Mr. Yanetti's own sort of what are the supplemental motions in support of this? How are we feeling? Are we ready for it? Do we have any questions before we get into it? Because we're going to get into it. So we're going to read Mr. Jackson's, Mr. Yanetti's. I think we have both of them. Yanetti's affidavit and Jackson's. Right. I think this was and Jackson's. And then we'll watch the instructions. We'll watch the mistrial reading. So we'll do all that. Does that sound good? Let's read through Ellen Jackson's support of Karen motions to dismiss honorable. Right? So sassy. Don't get in trouble in Massachusetts because you could end up with her as your judge. Don't be going to Massachusetts and causing no trouble now. Don't be doing that. Okay. So Ellen Jackson. I do declare. Oh my God. El Gato. Mr. Roboto. I don't know why it's doing that, but I'm at least in like 4K now, right? I don't know. I don't know what's going on. I'll fix it later. Oh my God. I'm like, it's like giving me like clear background, not clear background. I don't know what's going on. I will avoid Massachusetts at all costs. Yeah. Except for round one, because I love round one. All right, let's get into this one. Can I be in the bottom now? No. Can I be in the side? No. Do I have to be in the top? Yeah, probably. Oh, wait. Can I be in the middle? Okay. I'm going to be in the middle so I can see myself. Okay, let's see here. Commonwealth of Massachusetts, Superior Court, blah, 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 blah. Actually, I have a tea. It's just been sitting there, so hopefully it's fine. I didn't mean to cough right into the microphone. I need a little... I need a little something for my mouth. My mouth. I need something for my mouth. Oh no! I need something for my mouth. What's a girl to do? Who could help? Gross. Okay. Ellen Jackson. Let's get into it. This tea has just been sitting there for weeks. Oh my God, it's still good. I, Alan Jackson, declare I am a partner at Los Angeles law firm of Worksman Jackson and Quinn. See? Quincy? I don't know. I can't see because it's all a picture of a photocopy. LLP, and I have been licensed to practice law since 19. God, I'm gonna freak. Why? Okay. I'm just having confusion as to why this is happening. I'm just having a confusion moment. Sorry. And by confusion, I'm just mad that this is happening. I'm a partner at the Los Angeles law firm. I've been licensed to practice law since 1994. I was 4. How old is Alan Jackson? Not like that's not me trying to call him old, but he's been practicing law for a long ass time. 30 damn years. I am counsel for Karen Reed, appearing on her behalf in the Commonwealth of Massachusetts. On Tuesday, July 2nd, 2024, we're going to hear a little bit of the same as before, but you know. On Tuesday, July 2nd, 2024, I was contacted by Juror A, true name and identity withheld to maintain anonymity. Based on my conversation with Juror A and that juror's description of who he or she is, where he or she was seated, and certain identifying information, name/occupation, to close during their voir dire process, I was able to positively identify which juror he or she was, which is great. So the lawyers know who these jurors are. These lawyers have a whole voir dire of the jury to pick the jury, so they know where they work, they know their name, they know all that stuff, and they've looked at these folks for weeks, so they're able to identify them in that way. Juror A told me that she was seeing inaccurate reports about the split among the jurors related to the mistrial that the court declared the day before, because everyone was saying, even I, because that's where I was feeling, Massachusetts, more like massive 2 shits. That's a good one. Thank you, Steve. Everyone, what was I saying? I don't know. Oh, everyone was saying like 10-2 split on like not guilty, like they just can't get there, but the majority of them are saying that not guilty, because how could you get to guilt? How could you get to guilt from the trial that we all watched? We all watched the same damn thing. So that was what we were saying, and some of the jurors were like, absolutely not. Y'all got to get this straight. We were not guilty on counts 1 and 3. And so everyone was like, what? Stop, damn bubble. Okay. Juror A told me that he or she is seeing incorrect reports about the split among the jurors related to the mistrial that the court declared the day before. Juror A stated that she witnessed to be, let's start that again, because that's not words. Juror A stated that he or she wished to be respectful of the privacy of the deliberative process, but did wish to inform me of the true results of such process. Juror A indicated that he or she believes it important to disclose such results because he/she believes that those results significantly impact Miss Reed's rights. Juror A told me that the result of the deliberations was that the jury unanimously agreed that Karen Reed is not guilty of count 1, second-degree murder. Juror A was emphatic that count 1, second-degree murder, was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. Hi, jury drama, jury drama. We love jury. Well, we don't love jury drama. We wish the jury didn't have any drama after the case. The jury drama, but like during a trial, sure, that's normal. But like this, not so much. Not so much. I pick a case. I pick a trial, and I'm like, you know what? I'm gonna talk about it. I'm gonna cover it. And this is what happens. This is oh my God, I love it. It's so exciting. There's so much juice here. So much, the juice is running loose with this. Juror A told me that shortly, wait, Ronnie, thank goodness you're here. I'm not the Raylene was so excited. Raylene Raylene was like, I cannot wait to talk about this with everyone. She's like, I can't wait to hear what Ronnie has to say. And I'm like, Ronnie will be there. Don't worry. Don't worry. Don't worry. Let's see. Da, 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 da. Jury told me that shortly following that determination regarding count 1, the jury also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene with injury/death. I love our little community. I know. I do too. I'm so here for it. On July 1st, 2024, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review. Rather, the court indicated that the jury was at an impasse. Do you think it's weird, or do you think it's wrong? Do you think it was incorrect, improper for the judge to not read the note to counsel before declaring a mistrial? Once the jury was seated, the court then read the jury note verbatim in open court, and without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. Neither Miss Reed nor her counsel consented to the entry of the mistrial. But you didn't say it. Defense counsel was denied the opportunity to request that the court inquire on which count or counts the jury may have been deadlocked. Were they denied, or did they just not request it? Including lesser included offenses, and on which count or counts the jury may have arrived at a verdict. I mean, like, I'm all here. Sorry. I'm just trying to figure out what the hell is going on. It's making me so mad. They didn't request it. Okay, what happened? Where were we? This is short. It's like halfway down. You're 3/4 here because of the camera. Yeah, I know. Ooh, God. Okay, let's see. Okay, so the defense counsel was denied the opportunity to request that the court inquire on which count or counts the jury may have been deadlocked on. Okay, but like, you didn't like make a noise with your mouth to do it. Nor did the court on its own inquire of the jury foreperson on which counts the jury was at an impasse, and whether the jury could or did reach unanimous agreement on any of the other counts. Do we think it would have been proper if they were like, hey, so on all of them? so you're at an impasse on all the counts? And what's the breakdown in front of everybody? Like, do we think due to the nature of the case that should have been handled? We did hear that the court, the judge said that she was going to go back to the deliberation room and speak to the jury before they hop on the bus and go home. And we all kind of assumed that's when the judge was going to ask what the split was. But she did not. Because those conversations are recorded by the court clerk. And it didn't happen. That was not part of the conversation that the judge had in the deliberation room. So, had the court so inquired, it appears clear that not guilty verdicts would have been recorded for count 1 and 3. Miss Reed was denied her right to receive those verdicts in her favor. The foregoing is true and correct to the best of my knowledge and belief, under penalty of perjury, under the laws of the United States and the state of California and the Commonwealth of Massachusetts. So that was Mr. Jackson's supplemental situation. The whole ending seemed rushed. It did. And we're going to rewatch it with fresh eyeballs to see if it still seems rushed or if it seems like even more rushed. But I agree. What happened? Did she go back there and take a shot with them because it was over? I think she probably just went back there and said, "Thank you so much. Head on home. You're done. You're done." I think that's just what happened. I think she just wanted to say thanks so much for your work, your energy, your time. Appreciate it. Appreciate you. Uh and your duties are over with, when in fact they're not. But also, that is not, the jurors didn't ask her anything either. The jurors didn't bring it up then either. The jurors weren't like, "Hey, like, is it important to know how we're split?" Because turns out it's just on one of the counts, not all of them. Thank you. That'll be all. So let's look at Yanetti's affidavit as well. Just pulling it up here. Just pulling it up here. We're going to get into some crazy things today, too. So I don't want to spend too much time on it. I mean, like, we're going to spend as much time as needed. But affidavit of David R. Yannetti in support of defendant's motion to dismiss. I, David R. Yannetti, do hereby depose and state that the following is true to the best of my knowledge and belief. I am an attorney licensed in Massachusetts. I swear to God, Elgato. I swear to God. I am an attorney licensed in Massachusetts since December 20th, 1989. My main office address is this. If you need a defense attorney in Massachusetts, you know who to call or write a letter to. On January 29th, 2022, I was retained to represent the defendant, Karen Reed, regarding the above captioned matter. On July 3rd, 2024, I received communications from two different individuals, hereinafter informant B and informant C. So these folks reached out to Yannetti. The first juror reached out to Mr. Jackson, and these two informants reached out to Yannetti, who had received information from two distinct jurors, hereinafter Juror B and Juror C, both of whom were part of the deliberating jury. Okay. Okie dokie. You know, like, okay. We'll see how much he lands. It's hard to land too strongly on an informant gave me information about a juror. You know, like, it's hard to be like, ooh, like, here's so much type of thing. Like, it's hard. It's a little harder for me to kind of get behind and support than a juror spoke to me. Like, that's like, oh shoot, we have a problem. And an informant, someone who spoke to a juror, someone who spoke to someone who spoke to a juror is telling me these things, and this is a problem. It's a little harder for me to get behind, but the sentiment still between all of the conversations were pretty similar. And since these two folks reached out to Yannetti, I'm sure they're probably local. Obviously, they're like friends in that I'm sure they're probably local. And one juror reached out to Jackson. I think it might have been part of the conversation that they were having, because the jurors, like the whole jury, has their own little group chat. Juries on especially these long, difficult, high profile cases, they're spending day after day after day with these people. And just because they're not allowed to talk about the case, they can talk about anything else. They can talk about, birthdays and holidays and what you did over the weekend and cars and hobbies. Like, you can talk about anything. You just cannot talk about the case. And these juries get close. These juries relationships, like, are built. And I don't want to necessarily call it like a trauma bond, but a lot of them are sort of based in this whole like trauma bond aspect. I swear to God, if my camera, what the hell? What the actual hell? It's like a trauma bonding situation where you're all going through this really wild thing together, and you can't talk about it. Like, it's like you all have the same secret. And the relationships can last for a very long time, through kids and having grandkids, and like, you become a little family. And these folks had spent weeks and weeks and weeks with each other, and a lot of it they were in the break room just hanging out. How many breaks did they take? Yeah, so yeah, there's a group chat. The jurors are in a group chat, which I think is fantastic. I just want to know what they're talking about. All right, where were we? To my knowledge, informant B and informant C do not know each other. Okay. I want to do jury duty so bad. I've never ever been called. Oh, I've been called twice. Um, and each time, well, second time it was settled before the date even arrived, and so it wasn't necessary. And then the first time, I was so prepared. I had my little packed lunch. I was so ready to go. And we all were sitting there waiting. Then we had to watch a video, and they settled it before they just before trial started. So that sucked. I was so excited. I was so ready. I think it was like a month after I turned 18 too. Little packed lunch. I had like little cheese sticks. Oh, I was ready for it. I was so ready for it. And I was like, "You're so weird. Why do you want to be on jury duty? Like, why do you want jury duty?" I'm like, "Oh, I want to know. I want to know that. I know. I want to know what the hell's going on." So, on July 3rd, right here we are. On July 3rd, 2024, informant B sent me a screenshot he/she had received from someone here and after intermediary B of text messages that intermediary B had received from juror B. In this screenshot, juror B texted the following to intermediary B. It was not guilty on second degree and split in half for the second charge. When the judge sent us back with the Hernandez thing, the Tui Rodriguez thing, to look at the other side, it turned into a bully match. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. Weird typo, but they're probably texting super fast. They gave us free counseling forms when we left. Thank God. Because the amount of counseling is needed after this, I'm sure, is very extreme. They saw things we did not see. They heard things we did not hear. Like the children's testimony. They saw photos we did not see. They saw videos that we did not see. They saw evidence we did not see because we didn't need to. And a lot of people don't want to, you don't want to see it. Don't want to see it. So that's good. I'm glad that they got that. I hope they all take advantage of the counseling, the free counseling. Free counseling is great. Take the counseling. Based upon the first name of juror B given to me by informant B, I believe I am able to positively identify which juror he/she was and confirm that he/she was a deliberating juror. So on to the next. So basically it's just like I know who it was based on the description. On July 3rd, 2024, informant C contacted me to say that he/she personally knows juror C as they used to work together. Informant C and juror C also have a mutual friend here and after intermediary C, who is a current coworker and a friend of juror C. Informant C told me that she had posted something about the Karen Reed case on Facebook on Monday, July 1st. She told me that he or she believes that post led intermediary C to text him or her and inform him or her that juror C was a deliberating juror on the case. So someone made a post on Facebook, was like, this shit's crazy, right? And their friend was like, hey, so-and-so is a juror. And they're like, oh, no shit, let's chat. Informant C told me that they thereafter reached out to juror C via text message and discovered they experience as a jury and discussed their experience as a juror in very general terms. They discussed what an exhausting experience it was, and the juror C was relieved that it was finally over, I'm sure. I'm so mad at my camera right now. I'm sure. I'm sure. I'm sure that they were so happy that it was finally over. Intermediary C told informant C that juror C, good fucking, it's just like, it's just, and this is why this one is a little more tough, you know. Intermediary C told informant C that juror C would be participating in a Zoom meeting with a number of friends to discuss what happened with the trial. Today, informant C sent me 3 screenshots of a text message exchange they had with intermediary C. Oh my God. Informant C told me that intermediary C was reporting to them during this exchange what juror C had been revealed during the Zoom meeting. The text message exchange reads as follows. So, why? What is it? What is it that I'm doing? What is it that I'm doing? What is it? What is it, computer? What is it? I don't know. And I'm mad. Intermediary C. No consideration for murder 2. Manslaughter started pulling at 6-6, then ended deadlock at 4 no ATS. He was very consistent in the fact that they could only consider things that were admitted into evidence. Ultimately, they voted no because the cause of death was twofold of hypothermia and head injury, of which they were convinced that the vehicle did not cause both. Nope. This also gives us a little bit of insight as to uh, how the jury could possibly be confused. Um, you're in a room with 11 other people talking about what the hell just happened. You have to dump 6, 7, 8 weeks of trial just out of your brain, just to actually sort it all out with other people. So yes, the vehicle did not cause hypothermia. That's for sure. The whole jury felt very intimidated by Higgins' presence at the end. Yeah. I also they probably feared to answer any questions in front of him. So yeah, so there's that. I guess I forgot about that one. But also, you can there is a difference of like saying it and actually feeling the fear. Um so yes and no. They were not sure what they were going to do. He or she's going to lay low for a couple of days and see where it takes him or her. Hasn't ruled anything out. Okay. The jurors all have a group text going. They all have group text. Informant C. Interesting. If it was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict. This is from Informant C. Jury verdict slip, which is what they call it in Massachusetts. Not a form, it's a slip. That was all confusing. Okay. Intermediary C says she should have been acquitted. I agree. Yes, the remaining charges were what they were hung on. And that instruction paper was very confusing. Informant C, what a great experience for him or her. Amazing that they let the Alberta, I'm sure it means Alberts, in the last day. Intermediary C. He or she felt very honored to be part of it. He or she was, redacted physical appearance, physical description of Jersey. Everybody else was from a professional walk of life. They all got along and never heated. They agreed to disagree and respected each other. I love that. That is absolutely fantastic. Informant C, that's the way it should be. Oh, something new. It was an intelligent jury. They will be studying this case in law programs for years to come, i.e., how not to investigate and try a case. I mean, I think I don't they will be studying this case in law programs for years to come, i.e., how not to investigate and try a case. Okay, I'm a normal person. And I say that as like in this a sense that I'm not a lawyer. Um I don't need a legal background to know that this was just pure fuckery. Um so I think it'll probably be laughed at more than taught. I think it'll be like I think it'll be more of like the butt of a joke than taught, because golly, this was garbage. If they all agreed on no for murder too, they should make that clear to the DA and the court. It's basically a case of double jeopardy if she is retried on that charge. And so that's the sentiment that is going around that many folks are feeling here. Based upon the description of Juror C given to me by informant C, I'm so sorry about this fucking camera. I have no idea what's going on. Is it like, am I shaking my computer? I don't know. I don't know. I don't know. I don't know. I don't know, but it's making me upset. Based upon the description of Juror C given to me by informant C and confirmed by the redacted content of the above text message exchange, I am able to positively identify which juror he or she was and confirm that he or she was a deliberating juror. Signed under the pains and penalties of perjury this 6th day of July. Unetti is fantastic. So those were the two. Those are well, the three. That's what broke the internet a few days ago. Essentially, well, that's what broke our internet a few days ago. Depends on what internet you're on. I'm on Norfolk County is having a hard time right now, internet. And so yeah, so when that hit my desk, I don't have a desk. When that hit my desk, I was ready. I sent so many messages, so many messages. Um, so we talked a lot about that. We talked a lot about what's happening. Before we move on to anything else, let's go into um let's go into rewatching the jury instructions. Why is this blurry over here? The jury and oh my god. Let's go back to rewatching the jury instructions, and then we'll watch the last juror note being read, and then we'll talk about it. See how we feel now hearing the motion to dismiss and all the supplementary motions and affidavits. And so yeah, so let me put that up. Do we watch it on Law and Crime? Might as well. They did good to us throughout the trial. Let's see. Alec Baldwin is happening. While I'm looking for it, I can try to chit chat about the Alec Baldwin case. So Alec Baldwin is having a murder trial, essentially. Seeing if he has had any actual causation to the gun going off and shooting and killing Helena Hutchins. May she rest in peace. Young woman who died on set of Rust. Uh, man, I don't know. That's a tough one. So let's see. What day? Verdict watch. Verdict watch. Yes. There was discussion about finishing it. Charge. Oh, that's the charge conference, right? Shoot. There was discussion about finishing it about Helena Hutchins. I should have pulled this up. I'm so sorry. Helena Hutchins' husband picking it back up. But I think they are awaiting the end of this trial, of the trial as well. We can go back to this. Do, 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 do. Closing arguments, fantastic. And then, okay. 1 second. I found it, I think. All right, I need to do this. All right, sorry. I just need to plug in my headphones. Yes.
Thank you for serving on this jury and for being so attentive. You'll soon deliberate for the purposes of reaching a verdict in this case. But before you do that, it's my responsibility to give you instructions concerning the law. The instructions are divided into 3 parts. The first is general instructions that are provided in every criminal case. The second, specific instructions concerning the crimes alleged in this case. And third, guidelines for your deliberations. Please listen carefully to all of the instructions. Do not ignore any instruction or give special attention to any other instruction. To make sure that I give you the instructions accurately, I will read them to you. You will also get a written copy. I'll probably send in 3 or 4 to the jury so that you can refer to it in the jury room during your deliberations. I will try to make sure that my oral instructions match the written instructions. If there is any difference between what I say aloud and what the written instructions say, please follow what I say aloud.
I just had a talkie. If there is any difference between what I say aloud and the written instructions, follow what I say aloud.
You must take the law as I give it to you. You may not quarrel with it. You can't do that regardless of any opinion you may have as to what you think the law ought to be. What the lawyers or witnesses may say or suggest about the law is not necessarily the law. That's because it's my responsibility as the judge and mine alone to instruct you on what the law is. So I now will turn to part 1 of the instructions, the general instructions that apply to all criminal cases. As I explained to you at the beginning of the trial, there is a fundamental rule that applies in all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Ms. Reed is presumed innocent of the charges in this case. That means you must consider Ms. Reed to be innocent unless the prosecution is proved beyond a reasonable doubt through evidence presented during the trial that Ms. Reed committed the crimes charged. I will explain reasonable doubt in just a moment. Ms. Reed does not have to do anything to convince you that she is innocent. She does not have to explain anything. Ms. Reed does not have to testify, call, or question witnesses or provide any evidence at all, because you must presume she is innocent. Instead, it is up to the Commonwealth to prove the charges against Ms. Reed beyond a reasonable doubt. The burden of proof never shifts to the defendant. After you have considered all the evidence carefully and fairly, if you have a reasonable doubt about Ms. Reed's guilt in a particular charge, then your verdict must be not guilty on that charge. You may find Ms. Reed guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, how do you decide whether the Commonwealth has proven each element of an indictment is true beyond a reasonable doubt? Let's talk first about the roles we all have. You folks are the most important people in the courtroom. It all
And this goes back, there's already confusion, right? Like, there's already too much happening here. This is, I think it goes to splitting the charge. So splitting the charge when it comes is the judge giving some of this is what the prosecution needed to do, this is what the defense needed to do, reasonable doubt, before closing arguments. And then after closing arguments, here's what you need to do. I need you to come to these conclusions, blah, 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 the rules of the law, that extra bit after closing arguments. So when they go through and listen to closing arguments, they have like a refreshed memory, literally just told to them by the judge, of what they need to be really thinking about, instead of just hearing more words from these attorneys. I think it really would have helped and cut down on a little bit of the confusion. But let's keep going and listen to.
All begins and ends with your function. You will determine the facts in this case, and that is your job and your job alone. You are the sole and exclusive judges of the facts. If there are any conflicts in the testimony, it is your job to resolve those conflicts if you can do so. Once you do.
And I still stand on, I forgot what her name was. I am not going to pull up my notes. Paul's wife. I still stand on her just being tired and done and just emotionally exhausted, and sad for everything. She's sad for John. She's sad for her husband. She's sad for her husband's parents. She's sad for her friend Karen. She's done. Like, this is not, I'm here to intimidate you. This is, I'm here to support my husband. I'm here to support his family, support his loved ones. But I am so sad that I'm seeing my friend sit in that seat. Because her and Karen were close. And I stand on that. This back here, completely different energy. Completely different vibes from these folks back here.
To determine the facts, it is your duty to apply those facts to the law as I explain it to you, and to determine whether the Commonwealth has proven its case beyond a reasonable doubt. You must determine the facts solely and entirely on the evidence as you have heard it and seen it in this courtroom and on nothing else. No prejudice, no bias, no fear, no favor. You must not be swayed by personal likes or dislikes. Your deliberations are no place for emotion or sympathy, passion or prejudice. The Commonwealth and Karen Reed have a right to have the case judged by fair and impartial jurors. All parties who come before the court stand as equals before you. Therefore, your verdicts must be based on the law as I've given it to you, and on the evidence and the facts that you find, and nothing else. You cannot allow yourselves to be influenced by any personal feelings you may have about the nature of the crimes with which Ms. Reed has been charged or the consequences of your verdict. Just the cool, reflective, and impartial sifting of the evidence so that here in this courtroom, justice may be done. Now, your focus is on the evidence. I am the judge of the law. My job is to teach you the law that you must follow in this case. However, I have no opinion about how you decide this case. You should not consider anything I have said or done during the trial as reflecting any opinion by me about how you should decide this case. If you believe that I have an opinion about the facts of this case, you must disregard it. You must decide this case based solely on the evaluation of the evidence. Now, the arguments of the lawyers are not
Shut up about the evidence. I feel like if she really wanted to nail home the point of her not I really feel like if she wanted to nail the point home of her not of the judge not having an opinion about anything about the case, I feel like she should probably be a little more neutral throughout trials then. Um, she should be a little more not acting what I believe to be based on like opinion. Like there was opinion rooted in all of her decisions. And you could hear it. You could see the sighs, you could see the I'm bored, the I'm super bored moments. Um and I think it became very clear that the amount of time that Lally could just lallygag, you're joking. Oh my god. The amount of time that Lally was just allowed to just lallygag through everything, and then she say almost nothing, compared to when the defense was really trying to nail home a certain point or get a question answered. Yes, there's really only so much you can do if someone's actually not going to answer the question, but it felt like there was a lot more energy pointed towards um, the defense when it came to time limits and carrying on and all right, let's keep it moving, okay, and next question. Like it felt very, very biased. I mean, how much time did we spend listening to Lally talk about the weather? Just the weather. There's probably like four other things that we could just summarize his entire his entire case down to. I swear to god, I'm going to lose it. Why though? Like this is my thing. Like why is this doing this? Okay. Um is it true she wanted this case? I don't believe so. I don't believe I don't think she wanted this case. I think she was I think when it comes to what judge has what case, it's like a matter of scheduling, honestly. I don't think she stepped up to it. I don't It might have been on the table, like who can take it. Um like who has the availability sort of thing, and she was probably like, yeah, sure, I got it. And is it true she and Lily and Morrissey are all connected? They all work for the same district. Um this is not the first time Lily has prosecuted in front of her. This is not the first time Yannetti has stood in front of her. I'm sure. There's only so many lawyers, and there's a lot of trials. There's a lot of legal happenings. They know each other for sure. Their history and what uh their history and exactly like what is down that road, I'm not too sure. But if there is any sort of wrongdoing, these folks are not afraid of showing it and putting it on blast. So if people are looking into it, people are looking into it. People are looking into it, maybe. Maybe. All right, let's continue.
Not evidence. They are not witnesses. If a lawyer during argument made a mistake in summarizing the evidence or argued something not supported by the evidence, you must disregard it. It is the jury's collective memory of the evidence that controls the matter. Lawyers' objections are a proper part of the court's procedure and are not part of the evidence. So don't hold it against the lawyers or their client if they made objections, motions, or other requests. They're simply doing their job during a trial. There was testimony at trial that the lawyers interviewed witnesses when preparing for and during the course of the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the lawyers are obliged to prepare their case as thoroughly as possible and may interview witnesses. Now, the verdict must be based only on the evidence and the jury's collective reasoning applied to the evidence in a fair and impartial manner. The extent to which you believe or disbelieve a witness or what an exhibit purports to show, the importance to give any testimony or other evidence is entirely up to your own good judgment. The evidence consists of the testimony of the witnesses and the exhibits in the case. There are some things you have heard about that have not been introduced into evidence, such as written statements by witnesses, police reports, autopsy, and accident reconstruction reports. Occasionally during the trial, you have heard references to such documents, and you may naturally wonder why neither side introduced any of them into evidence. The answer is that under our rules of evidence, such reports usually may not be admitted, although the parties may refer to them for certain limited purposes while questioning witnesses. So you should not hold it against any party that you do not have them, and neither should you speculate on what they may or may not contain. Similarly, as you view exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try to guess what may have been removed or why. Any information that you may have read, heard, or seen about this case outside of the courtroom is not evidence. My instructions to you and any other comments I made, the lawyer's opening and closing statements, and any comments they may have made are not evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witnesses, that is, their answers to questions.
The lawyer's comments are not evidence. That was my favorite part about the whole trial.
And the exhibits are evidence. It is important to remind you folks that the verdict cannot be based on emotional reaction or sympathy for any person or side of this case. Certain of the testimony and exhibits may have provoked an emotional reaction in all of us. You may feel sympathy for the family of Mr. O'Keefe, and you may feel sympathy for the defendant as she sits here in this courtroom. But your job is to decide the case without bias, fear, sympathy, or favor, to view the evidence with a certain clinical detachment, and to decide the case based solely on the evidence and the application of the law to that evidence. I have allowed you to take notes during the trial, and you may refer to those notes during your deliberations. But remember, they are not evidence or a substitute for the evidence and your recollection. They are for your personal use. Please do not share them with other jurors. Consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Please keep an open mind until then. You'll remember that we took a view in this case. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the locations and their surroundings. Your responsibility in the view was to see the places, observe them carefully, and remember what you saw. The view is part of this case. You may use and consider the observations that you made while on the view in your deliberations in reaching a verdict. The same is true about the demonstration we saw from the witness stand. The demonstration was done simply to help you understand the evidence, and you may consider it in your deliberations. It is the jury's job to earnestly seek the truth of the matter. In doing that, the jury must decide questions of credibility and reliability. The jury must decide how truthful or reliable or convincing any part of the evidence is. In deciding questions of credibility and reliability, you may rely on your common sense and reasoning powers and your life experiences. Consider a witness's testimony in the context of all the other evidence, not in isolation. You may consider the demeanor, candor, and appearance of the witness in testifying. Who was the witness? What relationship did they have to the case or to the other witnesses or the parties? Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the witness and the assessment of the evidence presented. Is the witness someone likely to give an honest and impartial account? Consider not just whether the witness was honest, but also whether the witness's testimony was accurate and reliable or honestly mistaken. A prior statement by a witness, if inconsistent with his or her trial testimony in any way, may be considered on the witness's credibility and reliability, and only for that purpose. Now, you've heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider 3 questions. First, whether the omitted tests or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted tests or actions could reasonably have been expected to lead to
So are we
significant
confused
evidence.
yet? Is this confusing for a jury? Is this too much at once for people who have been sitting here listening to everything? Is this too much? Like, is this too much? I think it's too much. I think the charge should have been split. I think it should have been split. And the defense asked for it and she said, "No. This is a lot. This is a lot. You spend all these weeks listening and thinking and trying to understand and get a hold and get a grasp of the events and what happened and how it happened and who did what and who is this, and then we're going to go back to this, and then we're going to go take a look at this, and then we're going to do this, and there was no storyline, there's no story arc. You have just heard these 2 closing arguments, and now you have all of that. You have the closing arguments to take in. You have to have some sort of idea of what happened in opening, and hopefully that all the flow of everything sort of met each other. And all of the hundreds upon hundreds of pieces of evidence. You have like 75, 76 witnesses, and now you have a half an hour of the judge telling you all of this. Like, it just seems like a lot. Like, of course it's going to create confusion just for the the how to go do it. Just for the how to go do it. It just feels
Of
like
the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the test or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involve factual determinations that are entirely up to you. And you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. Now, during the trial, I gave you some limiting instructions on how you were to consider some of the evidence you heard, and importantly, how you are not to consider the evidence. I am going to summarize those limiting instructions here. Ms. Reed is not charged with committing
Right. Thank you. It is so true. Is this at all normal? I'm guessing addressing the jury in some way is, but what does it normally look like? It does look like this, and this is normal, but she's just boring as hell. It's just, it doesn't feel, um, it doesn't feel like, I don't want to say entertaining, but it's not like energized. She's not giving us a chance to like take it in and really hear it and to really get a grasp for it. And I think it all goes back to splitting the charge. I think it's just too much at once. Um, they have an idea when it comes to not engaging at all. Yeah, exactly. They have an idea of what closing arguments for the defense team is going to sound like, right? They have an idea of what the closing arguments for the Commonwealth is going to sound like, and it's going to sound like lollygagging through the entire thing, but they have no idea what the jury instructions are going to sound like, essentially. I mean, like, I'm sure there's a couple of jurors that may have been on jury duty before, that may have watched like the Johnny Depp trial or the Murdoch trial or something like that. They have some idea of what instructions are going to sound like, and the rules that you have to kind of follow. But golly, could she make it any more boring? And that's why I think splitting the charge is so important. Give them a little something, let it sink in as they're listening to closing arguments, and then give them a little something else. And I think that's I think it's a really good technique that I think she should probably do with, if this is her demeanor throughout trials. Um and if this is how she normally does it, and if she does have a higher than normal mistrial rate, she probably should change it up a little bit. Let's split the charge. It's okay. It's okay. It's still the same information. They're getting the same information, but they're getting a little breather in between to really take it in. Because this is a lot. This is a lot. And yeah, they're going to get printed copies of it. But she said, if the printed copy is different than what I say, you listen to what I say. Ma'am, I don't remember what you said. I don't remember what you said. How am I supposed to remember what you say versus how can I how can I fact check what you said versus what is printed on this piece of paper in front of all of us right now? That's where I find it very difficult. There, she said, if I say something different, you go by what I say, not what's on the paper. Okay, but if you don't say what's on the paper and I can't remember what you said, and I'm getting like just a gist of it, how can I fact check what you say? You're going to have to, well, hold on, guys. We need to make sure, verbatim, what did she say? Because a word here, a word there, you can get a totally different energy, answer, response, necessity when it comes to how to approach this piece of evidence. I would like it to go by what's on the paper. Strangest direction ever. It's backwards. It is backwards. It does feel very backwards. This the just boring as hell.
Committing any crime other than the charges contained in the indictments. You have heard evidence about interactions that Ms. Reed had with Mr. O'Keefe and other witnesses in Aruba. The evidence was admitted solely for your consideration as evidence of the nature of the defendant's relationship with Mr. O'Keefe and whether it goes to her knowledge or intent or motive on January 29th, 2022. You may not.
Like that, I feel like that could have been discussed with the jury prior to closing arguments. Or all of the earlier stuff that we just listened to for the last 15 minutes could have been discussed. There's ways to do it. There's ways to do it. Especially if she is this tired and she is someone who has signed up for this job. Like you put your name in the hat to be pulled, to be voted in to this position. Like you have trained for many, many years. These lawyers have been lawyering since 94 and 89, and you're a judge. Like, how do you think the jurors who are like essentially don't want a bench warrant out for him, legally obligated to be there. It's your civil duty. But this is her paycheck. Exactly. How do you think they feel? You know, like how do you give them a little sustenance, give them a little something. You know, you just been the whole trial is just you. I would expect more. I think she did a good job reminding the jury just how important they are, just how necessary they are. You know, the trial a trial isn't a trial for jury isn't a trial for a jury unless there's a jury. So they're the decision makers. You know, they have the ultimate job here. Um, but the underhanded like the backhanded compliments to the jury is very strange. I don't think that they really thought about the fact that this is a case when it comes to police being bad in the community that these folks live in. Um, and this is a difficult thing. Like this is more than just and I don't want to, you know, undercut John O'Keefe, but this is more than just a murder. You know, rest in peace. I John O'Keefe needs justice ASAP. But this is more than just a murder. This is about corruption. This is about how deep does it go? You know, like they're seeing all of these older people. And I don't mean like they're elderly, but they're older. They're veterans in their fields. Take the stand and not be able to answer a damn question about what they did in this case. You're seeing veteran officers put blood evidence in red Solo cups, put them in a Stop and Shop paper bag, and throw them in their car and say, but that was good, right? We did a good job. They're seeing someone call a friend about a leaf blow. Why do you have a leaf blower? In what we're leaf blowing snow now? You're seeing state troopers, state police officers not make reports. Like there's so much more, and I think the respect for the jury and the knowledge that the effects that this could have on the community that they live in. Hello? Like they live there. That's why they're called. Runs pretty deep. And so I don't think they showed enough respect to the jury, especially just let's just talk about the scheduling. Let's just talk about the scheduling. The scheduling of it. Okay, we're gonna have Monday, Wednesday full days, Tuesday, Thursday half days, and that happened for what, 2 weeks? And then everything was just a shit show. Like these people are not making money. What are they making, like $10 a day? They're missing out on jobs. You know, there's things that they are saying goodbye to their life for weeks on end. And this is how you're reading some of the most important words in this trial to them. I don't know, just doesn't fit. Just it's not quite adding up to me, and just a lot of this entire case is just not quite adding up.
Not consider that evidence as proof that she has a criminal personality or bad character. You may not take the defendant's prior acts as a substitute for proof that the defendant committed the crimes charged here, or to conclude that if she committed the acts in Aruba, she must also have committed the offenses with which she is charged here. You can only use the evidence for the limited purpose of how it goes to the defendant's state of mind, motive, and nature of her relationship with John O'Keefe. Before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the persons who authored them were in fact John O'Keefe, the defendant, or the witnesses who testified about their communication with John O'Keefe and or the defendant. If you do not find it is more likely true than not that John O'Keefe, Karen Reed, or the witnesses who testified here before you were the persons who authored or transmitted the electronic communications, then you may not consider the electronic communications in deciding the case. Now, the Commonwealth has introduced photographs into evidence. The photographs may be graphic and unpleasant. As I told you when you first saw them, your verdict must not in any way be influenced by the fact that these photographs may be graphic or unpleasant. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy. Consider a photograph only as it may show a medical condition, the nature of the injuries, or the details of the incident itself. You've heard evidence of statements made by John O'Keefe. These statements were admitted only for a limited purpose of establishing John O'Keefe's state of mind. You are not to consider this testimony as proof that the defendant has bad character or propensity to commit crimes. The testimony of witnesses recounting conversations with Mr. O'Keefe or messages the defendant's cell phone received from him can only be used as they go to the defendant's motive or intent on January 29th, and only if you find that the defendant was aware of John O'Keefe's state of mind at the time of the crime and would be likely to respond to it. There need not be direct evidence that the defendant learned of Mr. O'Keefe's state of mind, so long as you reasonably can infer from the evidence that she did learn of it. You've also heard testimony about statements allegedly made by Ms. Reed. Before you may consider any such statement, you are going to have to make a preliminary determination whether it can be considered as evidence or not, and for what purpose.
It just keeps going, right? It just keeps going.
It may be used. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she is alleged to have made, and that she made it voluntarily, freely, and rationally. In determining whether or not any statement made by the defendant was voluntary, you may consider all of the surrounding circumstances. You may consider any evidence that you have heard about the defendant's physical and mental condition, her intelligence, age, education, and experience. Your decision does not turn on any one factor. You must consider the totality of the circumstances. Some testimony came from witnesses who saw or heard something. Some witnesses also told you.
And it just keeps going. So I'm going to skip forward. Let's see.
Consumed any alcohol. However, no matter what the reading is, the blood test is not sufficient in dangerous or potentially dangerous fashion. The law considers an item, in this case, a motor vehicle, as you have reached a unanimous verdict.
Okay.
All the evidence. Communicate with anyone outside the jury room about the deliberations or about anything concerning this case. Further, I instruct you that no juror is better qualified to determine the truth of the facts in dispute or to deliberate on a verdict solely because of education, background, or experience. The parties and I have chosen each of you as fair and impartial jurors, and your voices have equal weight. To reach a unanimous verdict, each juror must agree. Jurors have a duty to consult with one another and to deliberate with a view to reaching an agreement if it can be done without violence to individual judgment. At the same time, each juror must decide the case for himself or herself, but only after impartially considering the evidence with his or her fellow jurors. Don't hesitate to re-examine your views and change your opinion if convinced it is wrong, but no juror should surrender an honest conviction to the opinion of fellow jurors simply for the purpose of returning a verdict. Although how you conduct your deliberations is up to you, I urge you not to begin conducting an immediate straw vote. Rather, I encourage you not to take any votes until you have completed a careful and thorough collective view of all the evidence. At this point, I want to remind you of an important issue that I raised with you at the beginning of this.
And that is, it's like the first urge. You want to get everyone back there. You got 3 charges. All right, deliberation starts. We have a 4-person. Where do we stand on 1? Raise your hand. Yes, guilty, raise your hand. Not guilty, raise your hand. Count 2. Guilty, raise your hand. Not guilty. You know, like you want to know where you have to go. But she said, don't do that. Just do a little chit chat first. Work your way through the whole thing. And then see where everyone stands. Did they do that? I don't know.
Of this trial. I told you that our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. I also pointed out that we all have our own built-in expectations and assumptions, even if we are not consciously aware of them. And I talked about some of the ways we can try to deal with them. First, slow down. Do not rush to a decision. Hasty decisions are the most likely to reflect stereotypes or hidden biases. Take time to consider all the evidence. Second, as you start to draw conclusions, consider what evidence, if any, supports the conclusions you are drawing and whether any evidence casts doubt on those conclusions. Double check whether you are actually using unsupported assumptions instead of the evidence. Third, as you think about the people involved in this case, consider them as individuals rather than as a member of a particular group. Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you are focusing on the facts or making assumptions, perhaps based on stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions. So don't be shy or hesitate to speak up. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you will do your part to reach a decision that is as fair as humanly possible. That is your responsibility as jurors. Now, during the course of your deliberations, you might have a question concerning the law in this case. I'm not suggesting that you will, but you might. Perhaps I said something you did not understand. If you have any questions, please feel free to bring them to my attention by writing a note dated and signed by the foreperson and sending it to me by way of the court officer. Because your role as the jury is to determine...
Right there, she said, if you have a question about the law, send us a note, right? Give us a note. Leave us a note. They didn't send a note questioning, do we fill out a verdict slip if one of the counts we are hung on? You know, if we have a unanimous decision on one thing and not a unanimous decision on the other, do we still fill out a verdict slip? Why didn't they send a note saying, do we fill this out? And how should we fill it out if we are undecided on one of them?
Determine the facts of the case. I cannot answer any questions you have concerning the facts of the case. I have no role in this case when it comes to deciding what the facts are. Neither is it possible to provide you with a transcript of the testimony, even though we've had a phenomenal court reporter throughout this whole trial. If you send a question to me, I will respond after consulting with the lawyers. Please do not ask a court officer or anyone else to answer any questions concerning anything material to the case. We will not answer a question or take a verdict between 1 and 2. You'll have lunch brought into you and decide whether you want to stop your deliberations during lunch or deliberate. At the end of the day, if you're still deliberating, I'll send in a note asking if you want to continue deliberating or break for the day and return tomorrow morning. Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before such time as you have reached a unanimous verdict.
Let's listen to that again.
Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before such time as you have reached a unanimous verdict.
Well, that answered our question as to why they didn't ask how to how to fill out the verdict slip if There's three charges, and one of them they could not become unanimous on. She just said, don't tell us that. Don't tell us that. Was that referring to each particular charge, each particular count, or the entirety? There's space here for confusion. There is space here for confusion, especially after just listening to like 40 minutes of all of the instructions.
You are going to notice shortly that the court officers are going to take an oath, and you will hear from that they too, as well as all other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching on the merits of this case. Remember that the decision of the jury must be unanimous, and the foreperson should be certain that each member of the jury is in complete agreement with the verdict. After the final vote of the jury, the foreperson should check the appropriate boxes as to each charge, then sign and date the verdict slips and notify the court officer that you have reached a unanimous verdict. You will
Per charge,
then be brought back into the courtroom where the foreperson will deliver the verdicts to the court. I'm going to see counsel before we reduce your number to 12.
So this is where they pick a foreperson and the two alternates. So there's space there for questions. There's space there for confusion. I can see it. That is true. Could it have been resolved pretty easily with a note to the court? Yes. Yes, we could have. Was it? No. And they're not to blame. Like, the jury isn't to blame for anything that's like happening now, right? They're not to blame for it. But if they had the question, if they had the confusion, if they had the thought, why not send a note? They knew they could send notes. They asked for stuff. What was it? The CERT team's report, but the CERT team did not make a report. So, oh, I totally forgot to show you guys this. And that makes me sad because I really wanted to use it as like a legitimate intro today, but I'll use it next time. Are you guys ready for this? This is my intro. Do you like that? Do you like that? How was that? How that yeah. So that's my intro that I need to remember to use at the beginning. I still got to make some other things, but little footnote. Not a lawyer. I'm not a lawyer. I don't want to be. I never wanted to be. But I just love all this legal stuff. So that's cool. So that's that. Whatever that was awesome. Thanks. That was my intro that I didn't use because I forgot. I get it. I'll remember next time. So let's, before we go into watching the final note and the mistrial being declared, what, if any, questions do you guys have so far in this specific situation? Because there's more situations. I'm just pulling it up now. So let me know if there's anything you want me to talk about before we get to the reading of the mistrial and what we think could have happened, should have happened, why didn't it happen, thing. Oh my gosh. I think this is before that. Let me just double check.
Yeah. All right. I think this has been an extraordinary jury. I've never seen a note like this reporting to be at an impasse. I do find that they're now, with the additional time that they went out without coming back Friday saying that they were deadlocked, is due in thorough deliberation. So I'm going to give Tui Rodriguez. So
okay. So that was the Tui Rodriguez given. So she called the jury back in for that. And then they went out to deliberate some more. And that's happening on the street. Did I miss it? Oh. Okay. Sorry, that was probably annoying to watch. I should have found the timestamp, sorry.
You see your closing session.
22-117 Commonwealth versus Karen Reed.
all right, the jury is at an impasse. So
That noise, did you guys hear it? I have a feeling that, like, I know it's not Yannetti, but I really want it to be Yannetti being like, oh, you know?
bring them in.
I think it's someone's like walkie-talkie. But that was that. That was the discussion.
Commonwealth versus Karen Reed.
All right, the jury is at an impasse. So we'll bring them in.
And let's feel the amount of time. They know she's going to be calling a mistrial because they're lawyers and they just had the Tui Rodriguez read and they're coming back without a unanimous decision. Nothing is being said this entire amount of time.
You guys for the jury?
Yes. Okay. So how long was that? I don't know, maybe 20, 25 seconds. They could have said, Your Honor, what the heck? I'm a lawyer, so I'm going to say lawyer things to put a pause on this real fast. You know? Yeah, she very much could have been like, jury's on their way in. Or whatever. I don't know. Whatever judges would say in that situation. But there's nothing was said. They didn't even move. They didn't even look at each other. So to sit there and say there wasn't an opportunity to have a discussion is, in my opinion, not fair. To claim that she didn't read the note to the in open court before the jury came in is completely fair because she did not. The jury is at an impact. Bring them in. Impact, impasse. To say there wasn't an opportunity to argue, not true. To say that she did not give them the chance to argue the letter, the note given to her is true because she didn't read it. They didn't know it.
Closing session, please be seated.
All right, Mr. Foreman, I am in receipt of your note. Judge Cannoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All rise for the court.
And that's when we thought that we were going to at least have it on record what the split was, so that eventually we wouldn't be able to just assume. We'd have the truth as to what actually the number breakdown. Give us the number breakdown, because she's like, I'll see you in a little bit. I'm sure it was probably just like a handshake and a see you later. Because she didn't go and ask, what's the split? What's the breakdown? Was there any chance to argue here at all? Of course not, because this is not a moment for lawyers to argue about anything when the judge is directly speaking to the jury. That would be completely inappropriate, in my opinion. But was there a chance to step in and say, hold on, let's pump the brakes? Yes. Did they take that chance? No. Did the judge read the letter before reading it out loud in front of the jury, just to the lawyers? No. So there was no chance to argue about what the next steps are, because they didn't really have the full context to, we're at an impasse. That's fair. Arguing, saying, hold on, we need more information about this impasse, right? But what if there was a majority guilty? That could be, like you're taking a risk at that moment. And I don't think they were willing to take that risk. They weren't ready to take that risk. They weren't prepared to take that risk. They weren't confident enough with this jury to take that risk, even though they really honestly should have been. If the reporting about the jurors so far in the timeline that we're walking through is correct, they should have been really confident with this jury. They should have been really confident. And I find that has happened. That happens a lot. There's the Alex Murdaugh case is a really good one. The jury, the jury was like, yeah, you're really super guilty, right? But there was like so much like, we want to just really, 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 really make sure that they know that he's super duper guilty. So sometimes it doesn't take much to prove guilt or innocence. This one just very, very a very strange case. The case itself is strange. How it has been handled inside the courtroom by the Commonwealth was even stranger, in my opinion. So I don't know. This is all just okay. I don't know why I hit play. So that's that. They leave. Everything's done. Goodbye. See you later. Let's see. What we have been going for 2.5 hours. We're gonna take a little break. I'm gonna put the only fan on, as Emily D. Baker likes to call it. I love her so much. No, I'm not gonna do that to you. I need a on break thing. I'm on a break for a second, and we'll be back. Let me see if I can find something super, super quick. As I'm doing that, if there's anything you guys want to say before we take a little breakaroo, because we'll come back and continue to talk about police officers, local constituents, and another juror event. Let me see here. Let's see. I'm just trying to find something. Okay, yeah, I'll just take one of these. Sure. All right, so I'm gonna download this. Let's see if that was. Oh, it's going. It's moving. Yeah, so we're gonna talk about police. We're gonna talk about city officials. We're gonna talk about all of that stuff very soon. I'm just gonna take a little short break and. Oopsie daisies. Let me put this. And this is just a temporary thing for right now. I'll make a better one soon. What's happening? All right, I'll see you guys in just a minute. Give it like 20 minutes. Yeah, we'll do about a 20-minute situation. Okay. All right, bye. All right, we are back. We are back. We are back. We have more things to go over. The chaos and insanity that is the Karen Reed case does not end there. So let's get skedaddling into some more things, shall we? So let's first start with Trooper Proctor. Let me pull this up and so we can go on through it. Okay. This one. I think. Yes, this one. Add to stage. Thank you. I will get really small, maybe in the top again. Okay, so let's talk about Trooper Proctor. We all know Trooper Proctor, the man, the myth, the legend, the worst guy in the scene. He's a naughty guy. Lead investigator in Karen Reed case, Michael Proctor, suspended without pay after internal hearing. This is an article from Boston Herald. There are tons and tons of articles. They all pretty much say the same thing. Let's read through it. We'll talk about it. I'll stop if I need to. Sorry about all these ads. I need an ad blocker. I don't have one because it makes things difficult sometimes. Oh, look at that poor face. Oh, sorry, guy. Okay. The lead investigator in the Karen Reed case, Trooper Michael Proctor, will be suspended without pay following an internal Massachusetts State Police hearing, officials announced on Monday. This was a long awaited. We heard that after the mistrial happened, Trooper Proctor was suspended with pay, awaiting his hearing. I couldn't think of the word. It was right in front of my face. Karen Reed, 44, of Mansfield, was tried for second-degree murder, manslaughter, and other charges related to the death of her boyfriend, Boston cop John O'Keefe, on January 29th. Oh, we never looked at the verdict slip. We never looked at we did never look at it. We had all of these things. Sorry. This I'll find a better one in a minute. We'll talk about it. We'll talk about Trooper Proctor. And then when we talk about the next juror, we'll talk about the verdict slip. How about that? Okay. Mistrial was declared on July 1st. Proctor's 2-day testimony during the trial led lawyers to reveal personal texts in which the trooper used degrading and explicit language regarding the defendant, leading to widespread criticism of the investigator's conduct and an internal review by the state police. Proctor was placed on leave the day the mistrial was declared. And we all remember the text messages. The no nudes yet. The messages calling her, I'll see you next Tuesday. Then the improper text messages going to friends and family, close friends of Officer John O'Keefe. The text chains, all of the improper messages. State police officials called a virtual duty status hearing for Proctor on Monday morning, in which a board of three commissioned would determine whether the trooper would remain on full duty, be placed on a restricted duty, be suspended with pay, or be suspended without pay. Proctor had the opportunity to be represented by counsel and defend his actions during the hearing. The board recommended Proctor be suspended without pay Monday morning, and interim state police colonel John Maughan accepted the recommendation effective immediately, the department said. So they said, you know what? You've done enough, Proctor. You've done enough. You have thrown dirt in our face and kicked us in our shins. You've done enough. We have, and this is me saying in my brain, not what they are saying to themselves. But in my opinion, this was the straw that broke the camel's back. They have allowed him to continue with his antics, and I said this during the trial. This is not the first time he has acted this way. This is not the first time he has run his job this way. This is not the first time he has run an investigation this way. This is not the first time he has acted this way. This is a community event. This is trained behavior. This is accepted behavior. This is applauded behavior that he had shown throughout the entirety of the investigation of this case and thereafter the investigation of the case. You know, the things he's done during the trial. He has carried himself in this manner for a very, very long time, and people are finally seeing it and pointing it out and saying, the hell's going on here? This isn't right. These aren't the rules. What do you mean we're okay with this? And so they had to listen to the constituent. They had to listen to the people, and I think they made a fantastic decision to suspend him without pay. Because what bigger slap in the face is it to the citizens of Massachusetts to say, yeah, no, he's super bad and like we're looking into it, but like he's got to pay his mortgage. He's got to pay his mortgage. What about that car note? Not with my tax money, like what do you like what do you mean? So I think they did a really good job. And let's continue reading. Colonel Mon said previously the state police will need to be in a continuous cycle of earning, maintaining public trust, and legitimacy following the highly publicized misconduct displayed at the trial and public outcry that followed. The state is currently in the process of seeking a new colonel to take over the state police. Following questions about the misconduct displayed in the retrial and other scandals within the agency, including overtime abuse, drunken driving, bribery allegations, Governor Maura Healey said the state is considering hiring an outside candidate for the position for the first time ever in June. Interesting. The state police internal affairs investigation into Proctor remains ongoing, which may result in charges that would be adjudicated by a state police trial board. It has not yet been made clear what Proctor may be charged with if allegations are determined to be sustained in the investigation. Proctor was also first subject to internal review following a federal probe into the O'Keefe homicide investigation opened in March. State comptroller records show Proctor earned $184,397 in the last year. In the last year. That's a lot of money. That's a lot of money. Proctor was placed on leave following the declaration of a mistrial on July 1st, which made him ineligible to work, and transferred out of the detective unit assigned to the Norfolk County DA's office effective Monday. He handed over his badge, his gun, his keys to the car. He was out of there. Okay, stop shaking. During his testimony at the trial during June 10th and June 12th, personal texts from Proctor revealed during the investigation he called Reed a whack job, expletive, and a babe, wrote no nudes so far to colleagues while searching her phone, and made explicit fun of her gastrointestinal issues, among other derogatory comments. In one text to his sister, he wrote, hopefully she kills herself, according to evidence presented by the defense. Could you imagine? Could you imagine? You're on trial for a murder that I'm going to say 99.99999% did not do. And the person investigating this homicide tells someone close to him, hopefully she offs herself. There's no way. There's no way. These regrettable and unprofessional comments are not something I'm proud of and are not something I should have written in private or any other setting, Proctor said during the trial on June 10th. Yeah, remember? Remember? It's so stupid. We hate him. We hate him. There's like, I don't even hate Lally, right? Like I can't even hate Lally. I can't even hate that man. I can hate Proctor. I feel like we can hate him. That's because that's crazy. Adding later that the comments absolutely do not detract from the integrity of the investigations or the facts derived from it is crazy to say. Is crazy. Adding later that the comments absolutely do not detract from the integrity of the investigation or the facts derived from it. How so? How so? She's a whack job, right? During the trial, the defense also discussed Proctor's familiarity with the Canton Albert family, which is central the defense's allegations that Reed was framed by a conspiracy to protect the family after they killed O'Keefe. And that's that. Yeah. Yeah, I'm going to say yep, there was a problem, there was a real problem with some of this stuff. So many ads. I got to get an ad blocker. All right, so let's talk about this one. This was the article that was written by CBS News when Proctor was suspended as well. Boston, Massachusetts State Police Trooper Michael Proctor is currently suspended without pay for his actions as lead investigator in the Karen Reed case. One law enforcement expert who was a state police trooper for more than 2 decades said Proctor's troubles could be far from over. Proctor's suspension went into effect on Monday. It is not clear how long he will be off the job, hopefully forever. Why did Trooper Michael Proctor get suspended? I like to get a couple of different viewpoints on a thing like this, because I like to kind of suss out the bias, you know what I'm saying? In one message he said, oh, during Reed's murder trial, Proctor was forced. That's cute. During Reed's murder trial, Proctor was forced to testify about derogatory text messages he sent to friends, family, and colleagues about her. Now, the bias from this, I can feel, but it could be from a couple of different sides. Like Michael Proctor was forced to testify about derogatory text messages he sent to his friends, families, and colleagues about her. Or he was forced to testify about text messages he sent. Text messages. There's just text messages he sent, right? There's I like to suss out some bias and try to get a feel for it. In one message, he said, hopefully she offs herself. While searching Reed's phone as part of the investigation, he said to a supervisor in a text message, no nudes so far. Mark that. He said to a supervisor. This text message wasn't just to a friend. This one was to, I think, a group chat, including the supervisor. And the supervisor did not shut it down. So this is all wild. On Tuesday, the State Police Association of Massachusetts called Proctor's suspension disappointing. On Tuesday, the State Police Association of Massachusetts, spam, called Proctor's suspension disappointing. Why was it disappointing? Were you disappointed that one of your fellows was suspended? Or was it disappointing that was one of your coworkers and he was a trash person? Where's the disappointment at? To date, we have received no information to indicate that his suspension was the result of anything other than these text message exchanges. Union President Brian Williams' statement read. How is his conduct not disappointing? Right. Yeah. Mm-hmm. Mm-hmm. Everything this man did was extremely disappointing, but you're mad that he got suspended? This is great. Wow, this is a lot of bias here. To date, we have received no information to indicate that his suspension was the result of anything other than these text message exchanges. Union President Brian Williams' statement read. Ugh, I can feel like it's just pouring off of this. Why? I don't like it. Text messages violated policy, expert said. Thank you. Good expert, whoever said that. Todd McGee was a trooper with Massachusetts State Police for 24 years before retiring in 2011. McGee said the text messages alone warranted punishment. Okay, go off, McGee. Go off. You have to understand that some of the conduct is in direct violation of department rules and regulations. So things like sharing state police business is a violation. It's a violation of confidentiality. The department has high expectations of all of its members to have the utmost integrity to maintain that level of confidentiality about police business, especially in a high profile case. So I don't think you can land on one thing that triggered a suspension without pay. I think it's a number of things to also connect to a high profile case. That is a fantastic statement by McGee. You just made a bunch of friends, McGee. I think it's a number of things to also connect to a high profile case. Fantastic. What could happen next to Trooper Proctor? Proctor's text messages came to light as a part of the federal investigation. Finally, was some sense over here. Yeah. That was that was fantastic. I think that was like lay down the law because they're not, and they're supposed to be upholding it. Like they're supposed like throw the book at them because they're supposed to know the book front and back. Because they have no shame. They do not quarrel with throwing the book at anyone that they want. Look at Karen Reed. And I hate to be like, oh, it could happen to anyone, but it could happen to anyone. And like they picked the wrong one. I've said this before. They picked the wrong one when they did it to Karen. They picked the wrong one. Karen has a little bit of money. She was lucky enough to have someone like Turtle Boy who found all of this information, who put energy behind it, who put it out into the internet, into the world. People like it, this garnered a response quickly before the fact. It wasn't a response of she was found guilty and now 3 years later people are starting to dig into it and we think it's a cover up. It was as things were rolling out, so was Turtle Boy, so was the internet, so was Reddit, so were the internet sleuthers. Like people were digging and it was like a communal, we've had enough. People are helping her with the financials. People are helping her with making this a high profile case. Like you don't have a high profile case without eyeballs, and she was able to garner eyeballs, and 2 years is a short time. It happened in 2022. Her trial was in 2024. That's really not that long of a time period. This spread very quick, and just during the trial alone, the eyeballs on this case exploded. People are like, I need to back up. I need to do some more looking. I need to do some more digging. It became so extremely high profile that what Proctor did, I hate to have to say it, but it was even worsened by the level that this case hit. It's so easy to be a bad cop in a super low profile situation, and no one does any digging from the outside. No one applies any extra pressure. No one can afford good lawyers. So it's so easy to be a bad cop in that situation, and he picked the wrong one. Play stupid games, win stupid prizes. It sucks that it took this long for you to win this stupid ass prize, but here we go. You know what I'm saying? Proctor's text messages came to light as a part of the federal investigation into the handling of Reed's case. Mind you, there is so many things and there's so much more than just us looking into it and talking about it and sharing it and posting and questioning and reading and this and that and gossiping. There's so much more. There is a federal investigation into the investigation of this case. There is internal affairs investigation into Proctor. There is there's so much happening, which is why it was just weird to begin with that this trial took place. That in itself was weird to me. So with the federal investigation, with the jurors coming forward, with Michael Proctor now being suspended without pay, job pending due to federal investigation and internal affairs investigation. We have, what's the other one? Kevin Albert. We have all of this happening. All of these things, the finalities of them, the findings, the end result of each of those things is going to impact whether there even is going to be a retrial. Because something like the federal investigation could come to a conclusion and be like, there's literally nothing, and that trumps everything. So the internal affairs investigation could come out. They could start digging into the one other person that needs to be dug into, and something happens. That was a lot of noise that was happening out there. Oh. So, between the federal probe and the internal investigation ongoing within Massachusetts State Police, McGee said it wouldn't be surprising if Proctor faces additional sanctions, which is you're a naughty boy and you're not just going to get fired. You're going to get charged. You're going to get charged. Like you caught a charge with this one. He's now in a holding pattern until the investigation completes itself. Then from there could be additional sanctions charged against him to include further suspension and up to termination. Hopefully, termination. McGee said, I think it's safe to say that there's more to come in the near future. We'll see how the case wraps up, but a couple of things we need to be mindful of. There's still this federal investigation that's out there. Does that mean there could be some charges brought against Trooper Proctor around civil rights violations? Is that the play? Very easily could be. From all the things that I've seen, very easily could be. Very strange and unusual case. Overall, McGee noted that Proctor's case has been unique because his punishment is a result of actions that are unfolding in the public eye, which I think, thank God, it's about damn time. I don't know all the things that he's done, but I know damn well this isn't the first time he's sucked. This is a story that is unique unto itself, McGee said. So many people, regardless of their vocation, from journalists to attorneys, to not attorneys, to law enforcement, are all seeing this very, very strange and unusual case fold out to us, who are none of those. We are not journalists. We are not attorneys. We are not law enforcement. We are just simply people who beg for peace and to not be falsely accused of murdering people. Okay, we read that one and we read that one. So that happened. And we were all like, yay, finally, cool beans. Super, 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 super cool. And then we get a little bit of this. Let me pull this up. Here we go. And then we get this. Order of impoundment. Okay. Order of impoundment. This is from, I don't know what date. I guess it's dated at the end. The order of impoundment. The Supreme Judicial Court has recognized that the safety of jurors is crucial to the fair functioning of the judicial system and that the justice system owes them the highest degree of vigilance for their personal safety. Okay, well, maybe don't allow corrupt cops into the courtroom to harass and um, scare them. But anywho, I digress. This case has garnered significant and divisive attention in Massachusetts and across the nation. The trial was live streamed on local and national broadcasting channels. The proceedings continue to be daily subject of commentary on various social media platforms. People associated with the case have been charged with intimidation. The court acknowledges that the names of impaneled jurors who rendered a verdict in a criminal case must be retained in the court file and made available to the public. Commonwealth. The jury in this case did not render a verdict. However, the court concludes that there is a real and present risk of personal harm to the jurors and to the integrity of their service. Consequently, the court finds that good cause exists to impound the list identifying the names of impaneled jurors in the trial of this case. The court further concludes that there is a risk of immediate and irreparable injury should the list be made available to the public at this time. This order shall expire 10 days from the date of issuance unless otherwise ordered by the court, for good cause shown pursuant to Rule 3B of the Uniform Rules of Impoundment Procedure. So what does that mean? That means that from 10 days on after this was filed by Judge Bev Cannoni, that the jurors' names will not be able to be accessed by the public. It will not be public information. It is sealed. Their information is sealed. And most likely, in my opinion, they will probably extend this until some conclusion happens, because there's so much going on, and more things just continue to happen, that as things continue to move forward, the risk is probably just going to increase, and hopefully that's recognized by the court. I too would probably like my name to be under seal. Your face is not under seal. Your face has been seen by anyone who's entered that courtroom while the jury was there. But your name was not known to them. So that was a thing. And then we kind of get hit. With this from the defense. Very soon after, defendant Karen Reed's supplemental memorandum in support of her motion to dismiss. So this is so you got the first one and the two affidavits. And here's like just another little nugget for you as well. Now comes the defendant Karen Reed by and through undersigned counsel. I feel like I keep saying Karen Reed by and through undersigned counsel, and hereby respectfully submits the supplemental memorandum in support of her motion to dismiss, filed July 8th, 2024. Are you guys ready? As reflected in the attached affidavit of Alan J. Jackson, a fourth deliberating juror. I'm going to say second. Technically second. Juror D has now confirmed that the jury reached not guilty verdicts on count 1 and count 3. We heard their argument for the first one, which was a juror reaching out to Mr. Jackson. We heard the argument on the other two. Mr. Jackson. We heard the argument on the other two. It wasn't the jurors directly that reached out to Yannetti. At this point, the the B and C intermediary informants that were talking to potentially juror B and juror C might have been or currently reaching out to Mr. Yannetti since their information was already sent. But that leads me to the question of, did the jurors, when talking to their friends, approve that information to be sent to Yannetti? Like, now that I'm thinking about it, if I were to sit with y'all on a Zoom call, like not on YouTube, like on a Zoom call, and just be like, oh my gosh, this crazy thing happened, da 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 da. I can't believe it went down like that, blah 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 blah. And then you guys took screenshots and took it to the lawyers of the thing that I did, and we're like, see, incorrect. I don't know how I would feel about that. I hope, I don't know, because we haven't heard from technical juror B and juror C, who had the informants and the intermediaries. We haven't heard from them yet, or at least we haven't heard from the lawyers that they've heard from them. Maybe they're pissed. Maybe, I don't know. I mean, I that's a hard thing to think about. Did those jurors want that information to go back to the lawyers? Or did they not want that information did they not want that information to go back to the lawyers? Ooh, interesting. Oh, brain, thank you for working. Okay. As reflected in the attached affidavit of Ellen J. Jackson, a fourth deliberating juror, I'm going to say a second, has now confirmed that the jury reached not guilty verdicts on count 1 and count 3. Once they were dismissed, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen Reed on count 1 and 3? No one ever asked about those counts. What? What? Juror D told counsel part of their discomfort was that they knew that the jury had reached verdicts on 2 counts and Karen Reed might be retried on those 2 counts, and that's just not right. What the hell is going on? Why didn't you say anything? Why didn't anybody say anything? Nobody said anything. Nobody said anything. And now we're here and nobody said anything. And now she's not, Karen isn't walking free. It was a mistrial. There's a potential for a new trial. Like a mistrial leaves the door open for a new trial. She has not been acquitted. I'm sure that a good chunk of the community that she has been tried in, I think she still has to maybe stay in the state. I don't know. I don't know what like her rules are that she has to, her guidelines that she has to abide by until a new trial or something like that. I'm sure that her lawyers know. But like, what's going on? How are all these jurors not in their group text being like, can we all just come forward and just be like, hey, like we know, like we all agreed not guilty on 1 and 3. Can we all just show up at Iannetti's office or something? Like can we all just send this email? Like can we all just reach out and get this done with? Because I want this to be over with. Like if I was in this juror, I'd be like, God forbid, I can't do this anymore. I want my freedom back. And I didn't murder anybody. It was never even alleged of me to have murdered someone. I was just called for jury duty. I want my life back. Like, where is that? What's happening? It feels like this has been going on for so long, not even a week. And this is a process that is going to take a very long time. And I'm already so exhausted with it. Based on the attached affidavit and all the reasons set forth in its opening motion, and the fact that the disclosures of Juror D completely confirm the veracity of the previously filed affidavits regarding jurors A, kind of B, and kind of C, the defense respectfully renews its contention that the jury acquitted Miss Reed on counts 1 and 3. Or alternatively, there was no manifest necessity for a mistrial as to those counts, and therefore the double jeopardy protections of the federal and state constitutions require that those counts not be retried, respectfully submitted for the defendant, Karen Reed, by her attorneys. They're like, we're done. I want to be done. Weinberg. Oh, is this what you were talking about, Ray? Because Martin G. Weinberg's on here. Yeah, I mean, they might have been like, "Hey, we're going Alan Jackson, we got things happening. Maybe we're going to pop in and see if Martin G. Weinberg can give us some assistance on stuff as well. Maybe this attorney has so like 617 Boston, Mass. They're both in Boston. They're really close to each other. Um Maybe this attorney has really good experience and they're buddies or something with experience with like mistrials and stuff like that, or jurors reaching out or something like that, and might have had a hand and is joining the team. Maybe. So that is we got a fourth one, folks. We got a live one. um this is Jackson's affidavit for juror number 4 as well. I, Alan Jackson, declare a partner at this place, Counsel Karen Reed. On Monday, July 8th, I was contacted by Juror D. So this was Mr. Yannetti and Mr. Jackson were both contacted by this juror. So just this juror was adamant about getting someone's attention, and he got both of their attentions. Mind you, Alan Jackson is out in California. Mr. Yannetti is here, not here, there in Massachusetts. Based on my conversation with Juror D and that juror's description of who they are, seated information, identity, they know who it is. Juror D told me that they decided to reach out to me because they were uncomfortable with how the trial ended. They said that the last day of trial was a whirlwind and everything happened fast. They recounted that their perspective was that the jury was brought into the courtroom, the note was read, the mistrial was declared, and the jury was then rushed out of the courtroom. Following a brief meeting with the judge, did you bring it up with the judge? The next thing they all knew, the jury was on the bus. They described the end of the trial as very confusing. And this is going to be as close to firsthand reports that we're going to get for a really long time until this whole thing is settled. I don't think any jurors are going to be speaking willingly to media, especially now that this is all happening. Juror D said it was very troubling that the entire case ended without the jury being asked about each count, especially count 1 and count 3. Juror D explained that the jury reached not guilty verdicts on count 1 and 3, and that the disagreement was solely as to count 2 and its lesser offenses. Juror D said the jury actually discussed telling the judge that they had agreed unanimously on not guilty verdicts for count 1 and 3, but they were not sure if they were allowed to say so. They were not sure if they were allowed to. And the only way you can find out if you're like in that situation, if you're not allowed to, is to try. You got to try, right? This is a woman's life on the line. This is like improper. This is a mistrial gives no justice. There is no justice for John O'Keefe. There is no justice for those kids losing a third guardian. There is no justice for that family losing a son, a brother, an uncle. There is no justice for that in a mistrial. You gotta try. But again, it's not the jury's fault. They're not lawyers. They're not, I'm torn up inside about this. I am torn in so many different directions with this. The jury believed that they were compelled to come to a resolution on all counts before they could or should report verdicts on any of the counts. So that's where a lot of the confusion sat, stood, landed with the jury. They were told to not tell anyone anything about what's going on until you have unanimous decision. It was never clarified if it was a unanimous decision on all counts or one count or some counts. After discussion, the jury decided to inform the court that they were deadlocked and they expected they would give further instruction about the remaining decided counts thereafter. Juror D explained that they were confused and upset that such further instruction never came. Juror D explained that after the jury was excused and aboard the bus, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen Reed on count 1 and 3? No one ever asked about those counts. You also never told anybody. But there's a power dynamic there. They're just the juror. Rushed. I do agree. It was rushed. I do agree. I do. Juror D stated that once the case was over, they remained very uncomfortable with the result. They reiterated it did not feel right. They said that part of their discomfort was that they knew that the jury had reached verdicts on 2 counts and Karen Reed might be retried on those 2 counts, and that's just not right. I inquired whether, in their opinion, other jurors would agree and acknowledge that not guilty verdicts were reached on count 1 and 3. Juror D, without hesitation, said in substance, every one of us will agree and acknowledge that we found Karen Reed not guilty of counts 1 and 3 because that's what happened. That's big. That right there, that's massive. That's big time. I inquired whether, in their opinion, other jurors would agree and acknowledge that not guilty verdicts were reached on count 1 and 3. Juror D, without hesitation, said in substance, every one of us will agree and acknowledge that we found Karen Reed not guilty of counts 1 and 3 because that's what happened. That is big time. Mic drop. Yeah, exactly. That's a major mic drop moment. Like it almost gives me like a little bit of relief that okay, there's options here. There's ways that we can do this. If that is true, this can be resolved properly, legally. I don't know the exact terms because I'm not a lawyer or a judge, but this can be resolved. Jury D reiterated that they believe that it would be unjust for Karen Reed to be retried on either count 1, second-degree murder, or count 3, leaving the scene with injury or death, because the jury has already unanimously found her not guilty of those charges. Juror D further stated that if necessary, they would agree to testify in order to explain to the court that the jury unanimously reached not guilty verdicts on count 1 and count 3, as long as their identity remained protected. Fantastic. They said, put me on the stand, boss. Put me in, coach. Put me in, coach. We got this. But this begs me to question, where's the other jurors? Because I'm going to stick with 2 jurors have come forward. I'm going to stick with 2 jurors have come forward. The other 2 jurors, B and C, the intermediaries and informants, they haven't personally come forward to any lawyer, to the district attorney's office that we know of. Maybe, but it would be completely improper to not affidavit that, to not put that in an affidavit about what's going on. Completely improper. That needs to be shared information. And if it was not guilty, why would they go to Lolly? Why would they go to Lolly? They're going to go to the defense attorneys. So where are the other jurors? Where are they? They haven't come forward yet. It's been a good chunk of time. Are they just busy? Is that an excuse? This information is here. How to reach out is there. They could literally just call the courthouse and say, I need to reach this lawyer from this case. And they'd say, okay, here's their name. an address, phone number, for their office. I'm sure they would, right? Also, you're in a group chat with all the other jurors. Ask them how they did it. I need all the jurors to come forward. Now, to be fair, Google. To be fair, there's fear, I'm sure. There's reluctance, absolutely. Those that might have been on the guilty side for count 2 might have a now opinion, not a then opinion, but a now opinion of maybe we need a little more. Maybe it needs to be done again. But the judge can call the jury in. It is not abnormal. I mean, it's a little abnormal, but it's not unheard of for a jury to be questioned post verdict. Can be done. They have a hearing on the 22nd. Hopefully it's streamed. I think it will be. At this point, it fucking better be. If it's not, I'm gonna be pissed. I think it will be. And we'll watch it. We'll go over that as that's happening. Because I want to know what's happening. I want to know what's going on. And I want to see the defense push to get, if it's not scheduled for it already, to get the jury in, to get them questioned, to get the information that's needed for this acquittal if they really did come to a unanimous decision for counts 1 and 3, not guilty. It's fair. It's fair and due. And I think it's really good that on record, there's already the defense arguing about the verdict slip. Let me find the verdict slip. Verdict slip. I think it's in this Reddit. Let's look at them. Okay, verdict slips. Oops. I know that this was of importance for many to see again. So let me pull them up. So verdict slips. Oh, maybe it's so hard because it's like a picture of a photocopy. So Commonwealth of Massachusetts, Norfolk, or Commonwealth v. Karen Reed, a verdict slip. Offense number 1. I'm not going to read all those numbers and letters out. Murder in the 2nd degree. In the above entitled case, we the jury say that the defendant is 1, not guilty, or 2, guilty of offenses charged, murder in the 2nd degree. Put a check. Put a little tick. Put an X. Circle it. Circle the whole fucking thing. Initial it. Highlight it. Cross out number 2. Cross out guilty. Underline not guilty. Give me something. Give me something. This is not like in evidence. This is just a copy of. This is not like the filled out, like the final piece of it. This is just a photocopy of it. So this is what they were given. Offense number 2, manslaughter while operating a motor vehicle under the influence. Okay, so this is where they were torn. This is where they were at an impasse, allegedly. In the above entitled case, we the jury say the defendant is either 1, not guilty. And mind you, this is the amended verdict slip. Because the other one, remember, it was like not guilty wasn't an option. It's like, well, just don't cross it. She had to re-give that information about the verdict slips. We were there. We remember. 2, guilty of offenses charged: manslaughter while operating a motor vehicle under the influence. Check one or both of the following: manslaughter while operating a motor vehicle under the influence of alcohol, and or manslaughter while operating a motor vehicle with a blood alcohol level of 0.08 or greater, which I think is absolutely bonkers for it even being there. I think that's absolutely bonkers. We have no absolute we have evidence, but in my opinion, we have no absolute evidence that was even like on the table. Like we have blood alcohol evidence, but golly, was it a lot of guesswork to get to like a number, you know? Number 3, and this is all under offense number 2. Guilty of lesser included offense, involuntary manslaughter. And number 4, guilty of lesser included charge of motor vehicle homicide, felony OUI, liquor, and negligence. Check one or both of the following: motor vehicle homicide by operating a motor vehicle under the influence of alcohol, and or motor vehicle homicide by operating a motor vehicle with a blood alcohol level of 0.08 or higher. This is confusing, right? So if they are not guilty, if they were to come back with a not guilty verdict, let's just talk about offense number 2. If they were to come back with a not guilty verdict for offense number 2, they would check not guilty. Now, if they were to come back with some sort of guilty verdict for number 2, they would check one or all of these. If they wanted all of them, if they said yes to all of them, they could check all of them, or some of them, or one of them. Guilty of involuntary manslaughter. Let's just go with number 3. Check number 3, but not guilty of number 2 and number 4. There's no not guilty line to check for them, and so when you see it, like, I can see where the confusion would exist in a room full of 12 people with completely different ways of interpreting this. I can see the confusion. I can see it happening. If it was me personally on my own, I would be like, all right, well, okay, if I wanted number 4, I'd be like, that's this one and this one, like something like that. Like if I wanted number 4 and I wanted the blood alcohol one, I'd be like, okay, this one, and then just ignore the rest, because you can't have not guilty for all and then also like pick one, but to be fair, it's not just one person in there. It's 12 people, and there's a lot of voices, and there's a lot of opinions, and there's a lot of varying factors, and there's a lot of movement with opinions. People are going to be communicating about it, and sometimes the more you talk about something, the more confused you get. But they still had an opportunity. Too confusing, not guilty, honestly. Like, if they're not guilty, and we'll get to the third one in just a second, but if they're not guilty of murder in the second degree, and if they're not guilty of leaving the scene of an accident resulting in death, it seems a little funny to me that they could find a way to negotiate some sort of guilt for manslaughter while operating a motor vehicle under the influence. Because if they didn't leave the scene of an accident that resulted in death, and and they didn't do a murder in the second degree, this one seems kind of like a given, like a not guilty, bro. Also, how are they going to charge her on DUI anyways? They were all drinking. Exactly. Why does a civilian have a higher standard when it comes to a DUI than literal police officers? They were all drinking, and that's the point. And I think, well, that's another thing that we will come to do a little chit chat with when Kevin Albert, which we're getting to. We're just going through the timeline of how all the things in the past week and a half went down. But yeah, we're gonna get to the drinking. I'm gonna get to the drinking too. God, it sounds like I've been drinking. All right, offense number 3: leaving the scene of an accident resulting in death. In the above entitled case, we the jury say that the defendant is not guilty or guilty of offense as charged, leaving the scene of an accident resulting in death. A lot more clear than offense number 2. And how would I change this? That's a great question. Thank you so much for asking. You guys are so how would I change this? I would change this. I would remove not guilty completely. And I would give each one of these an option to say guilty of offense charged, click this and or this, or not guilty. Guilty of lesser included offense, involuntary manslaughter, or not guilty, and have a not guilty option for each one. I think that is probably one of the only ways. I'm also I have an open mind, but I don't have the information for that open mind for any other way. This is just as my layperson imagining of something that is a little more verbiage hefty when it comes to a document like this for humans that do not have a history in legalese. And yes, there's not a lot of legalese in here, but yes. Yes. They settled for a simple not guilty like this on the top. Um, but they definitely wanted each option to have a not guilty so that there was a reciprocal option as well. It's either this or this, like it's either like you can have a ham and cheese sandwich or you cannot have a sandwich. You can't just have a slice of cheese. That was terrible. That was the worst. I'm sorry. So yeah, so I can see how the confusion happened. I don't see how no one out of 12 people, no one stepped up to say, but what if, can I ask a question? What if there was hypothetically, you just watched weeks and weeks of lawyers saying, well, hypothetically in a trial that's supposed to be full of evidence, that isn't hypothetical. Well, hypothetically, what if there was an offense that there was a unanimous decision on, and there was something that wasn't? I ask questions. Ask questions. So yeah. So that's that. It is what it is. It's done now. You can't go back in time. Trust me, if you could, I would have already been there. Not for this. That's none of my business. I would have been other places. But let's now jump ahead to the Canton Select Board meeting from the 9th of July. The 9th of July. 'Twas the 9th of July. Share screen. Yeah, so let's jump ahead to this. And we shall overcome. I don't know what the best placement for me is going to be. I have a feeling right there should be okay. All right, so let's talk about Canton Select Board meeting. This is where local folk can come and have an opportunity to be heard by local local officials who were voted in, who help to push decisions through the city, like hiring chiefs of police and stuff like that, holding other local officials like law enforcement officials accountable for their actions, helping the city make decisions when it comes to permits and stuff like that. It's like a city board. It's like a town hall city board meeting situation. So this is the Canton select board meeting from July 9th. Dude Icarus says healthy living had teriyaki beef kebabs and they were to die for. I want one. I want a beef kebab. That sounds delicious. I have my Takis. So let's give this a listen to. We are going to listen to civilian folk speak. They have a 15-minute time frame, and as you could imagine, on the 9th, things have already been heating up post mistrial. And we are going to hear opinions and thoughts. It's probably going to be, there's times where it's going to be like a little bit muddled and a little bit like, what the heck's going on? It's people who are upset and have things to say.
In consideration. The select board will also announce the next open office hours at our next select board meeting. So that being said, we will begin our public comment period at 7:01. So, Ms. Smith.
Christine.
This was, it's not me.
Policies and ethics of select board members. After submitting my comments, Town Administrator Charlie Duty let me know that his office would work on this and they thought it would make sense to perform a complete update of the administrative code, not just this one section, and that made total sense to me. I offer my sincere thanks to Mr. Duty as well as to Jen Kamalian from the Select Board office for all of their work on this issue. However, the revision to the standards, policies, and ethics seems to have gotten a little derailed. I'm not sure if it was due to an attempt to include other boards, or maybe this is going to fall under the Bylaw Modernization Committee. I'm not sure. But
This is by the Young Jerks. So this is their video that we are so graciously borrowing. Please don't please don't copyright strike me. I don't think you can, because but yeah, so ignore all of that. But good for them. Yes, go memberships.
But either way, we continue to see that certain select board members continue to ignore the spirit of the current guidelines, notably swearing at and threatening to assault an individual on the sidewalk right in Canton Center. I stand here today to renew my request for the select board to take action on this matter. You represent the town and all the citizens, not just the ones who voted for you. And yes, as public officials, you are held to a higher standard. This continued behavior reflects poorly on the town and has the potential to expose the town to liability. To be clear, this is not about the Reed case or any other matter. It is about leadership and leading by example. It is disingenuous to sit there and object to lack of civility when one of your own members acts in an uncivil manner with no comment or consequences from the rest of the board. Thank you.
Thank you, Ms.
Everyone gets about 3 minutes.
Hello, Ken. I'd like to reintroduce myself. My name is Colleen O'Neill, where I formerly worked at F&F Power Equipment on Walpole Terrace in Canton, Mass, alongside my longtime boyfriend, Jeffrey Farrington, a longtime Canton resident, whose father retired as captain of the Canton Fire Department. Recently, we were informed by the town secretary, Charles Duty, that our case regarding commercial vehicles parked overnight was on the agenda. Today, an executive session that was held at 6:15 p.m. tonight was held to discuss litigation concerning Walpole Terrace. Despite enduring significant harassment while working in Canton, Massachusetts, I have since moved my career to Boston, specifically working on Mass Ave, known as Massencast, where individuals facing severe drug addiction and dual diagnosis mental health disorders reside on the streets. The ongoing harassment from Canton
I'm just going to pause. Now time to resign, Chris. It's referring to Chris Albert. Truth and justice for John. Free Karen Reed. There's energy here. These are people who live here, who are speaking directly to the first line of defense. Speaking to the people who can do the most for their town. They're not speaking to at a presidential what do they call them? Open house? Not an open house. Town hall. You know, they're not begging for health care and civil rights. They're talking to their neighbors about holding their other neighbors accountable for the I don't want to say terroristic acts, but the not cool crap, the garbage activities that have happened in this town. The people are done. The people are putting their foot down and they're saying, you are going to listen to my story and you are going to make the change that we are all requesting, because that's your job. You put your name on the ballot and you won. Do your job. So, yeah, as you can tell, this is a small
including
room and it's
unjust
packed.
fines, unwarranted visits from a sexual predator, Canton cop Eric Wade, and personal property issues involving another corrupt Canton officer, Charles Ray, who
The
altered
accent
zoning
is
regulations
so
in
great.
2016, has compelled me to leave the area. I now collaborate directly with the Massachusetts state government to provide housing for people with severe mental health illness. I have reached out to Governor of the Massachusetts, Maura Healey, and Boston Mayor Michelle Wu regarding Jeffrey Farrington's property on Walpole Terrace, proposing the construction of 40B housing for housing undocumented immigrants.
Okay, so this is not, a Karen Reed this is not, you need to free Karen Reed, da 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 da. This is not directly about Karen Reed.
Relentless cycle of lawsuits, police misconduct, and unfair fines that plague running a business in Canton, Massachusetts. This clown town of Canton has caused nothing but harassment to a small business and caused extreme emotional distress to Jeff's and I personal relationship. This harassment needs to end.
She did go over a little bit,
Sean Colburn.
I believe, or maybe
Mr.
not.
Chairman, I would like to address some questions I have for you guys, since we weren't afforded the opportunity 2 weeks ago to address items that were listed on an agenda with the reappointment of the police chief. And I had planned on going through and asking each one of you guys how you voted and what you some of the questions you asked her were. How was the determination decided on to reappoint Helena Rafferty to a one-year contract? Did you interview?
This man has some questions.
You and
He wants
assess her
answers.
performance one-on-one, or was it done as a group? Does the chief recognize the missteps that have occurred in the Canton Police Department investigation and the death of the officer John O'Keefe? Can you tell us what some of the questions you asked her were? What, if anything, did you ask her about her department's lack of following proper procedures and policies? What, if anything, did any of you ask her about the importance of interviewing and separating witnesses?
Helena Rafferty is the chief of police in Canton, and she was just reinstated for another year.
In recording witness statements? What, if anything, did you ask her about the collection of evidence, the proper storage of evidence, and the chain of command on evidence collection? What, if anything, did you ask her about recognizing and adhering to conflicts of interest?
What, if anything?
Such as when the chief at the
did you
time,
do?
Chief Berkowitz, called District Attorney Michael Morrissey's office at 8:30 a.m. on January 29th and talked about the Canton Police Department recusing themselves because of a conflict of interest. When through testimony, we learned that the Canton Police Department actually did not adhere to this recusal. We had a Canton police officer, Kevin Albert, arranging witness interviews days later after they were recused. At 8:30 a.m. on the 29th, the state police took control of this investigation. Why were the Canton police officers in the Sallyport at 5 p.m. on January 29th? And why was an ATF agent also in the Sallyport?
Why?
The ATF has no jurisdiction on this case at all.
Huh.
Yet Brian Higgins was allowed to be there. Who were the three officers that were not identified at 34 Fairview? Did any of you ask her how an inverted videotape was turned in as evidence? Did any of you ask her how 40 minutes is missing off?
Can he come watch my streams, please? And thank you. I think he would be a great addition to us, right? Because he's clearly super in the trial. He watched this guy. This guy is great. He watched every single minute of this trial. He heard every single word said. And he still has questions and he wants answered. He knows he's not going to get he knows he's not going to get answers right now. They can't answer right now. But he's asking the really important questions to the people who are able to say shit needs to change. We love protect this man at all costs.
Off the Sallyport video? How about the library video? And what, if anything, was done in regards to the testimony in the text messages read from State Police Sergeant when they were driving around the Cape in a State Police cruiser, shitface, and the Canton Police officer, Kevin Albert, lost control of his badge and his gun? Were they ever recovered?
Because y'all remember Kevin Albert and Proctor getting shit-faced out on the Cape. Love Cape Cod, by the way. Out on the Cape, getting text message, hey, I'm so hungover, man. I got a super hangover, bro. Right? I got a super hangover, bro. We drank so many beers together last night. Hey, do you know where my gun and badge is? Don't know about your gun, but I got your badge in the car. Oh, do you mind putting it in my mailbox? Thanks, bro. Like, what the? I don't know what it was. I don't know what that was. Don't ask me what that was. But that's basically it. That is basically it. And that's trash. That's not good. That is a bad thing. And that's not good. You can't just get drunk and misplace your gun. What is this, a Will Ferrell movie? Like, you can't do this. That's not acceptable. And that happened years ago.
Was there any disciplinary action taken? I think these are just a few of the things that come to mind. This is your job to ask these questions, not mine. We are the taxpayers of this community. We should.
This is your job to ask these questions, not mine. We pay you to have this under control so we can go on with our daily lives. Do you want more protests in the street?
To ask these questions, not mine. We are the taxpayers of this community. We should have been afforded the opportunity to ask these questions 2 weeks ago on an item that was listed as an agenda item. You were in violation of mass open meeting law. Thank you.
Well done. Applause. Give that man. Everyone go give him a gift card to his favorite ice cream place. Like, that man needs scoops for days, because that is exactly how this scenario needs to be approached. Calm, cool, written down, prepared. You know what you're going there for. You know you're not going to get answers right now. This isn't the time for the answers. This is the time to be heard. And yes, like, you get 3 minutes when these bad folks have been being bad forever. Like bad cops is not new. Bad cops is not new. Bad city officials is not new. Corruption is not new. This is just as any ism is systematic, so is corruption. Especially when it comes to cops. There's energy to suppress the bad. There's more energy to hide all of the crimes that cops commit. There's more energy for that than to protect and serve. Ha, I get it. The Cops Bad Boys theme song is about them. Yes. Yes. There's so much more time and energy into making sure cops can be bad than there is to actually protecting communities. And it is an agenda that is passed down and 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 handed down to brother after brother after brother after brother, and in this case, sister, like there's that it is handed down. It is embraced. Being an asshole is embraced. I'm not, oh my God, I'm not saying that being a cop is an easy job. What I am saying is that, in my opinion, those who want to be cops are the people who exactly should not be cops. Those who wake up every morning and say, oh, I can't wait to have a gun and be able to arrest people and have power are the exact people that should not be cops. Because it's not about that. It's about making sure your community is safe and protected and comforted. And know that you'll be there when needed. And when needed, your first option isn't just to shoot to kill. Like that's all my opinion. Like I don't think it's hard to talk about cops, but in this instance, corruption is king. Corruption pays the bills. Because if it didn't, because how did Proctor become the way he is? How did Proctor become the type of person to say, within 8, 10, 12 hours of having a case, he's calling the very first person that is not a relative or married into the family that this is all taking place on, a see you next Tuesday, a whack job bitch or something like that? What made him like that? Was it the years on the force, the training that he had? It's all systemic. And I think the sooner people recognize that it's not just a couple of bad apples, the sooner things can actually be good. It's not just a couple of bad apples on the force. It's bad apples as their bosses, as their trainer, as their trainees, the newbies, the rookies. It's the bad apples who taught the bad apples who taught the bad apples who are now in government, who want to be a bad apple but not have to drive around in that heavy gear. It's a vein, and it's an artery that runs through the entire system of government. And we'll see here in just a little bit. My street is a prime example. You know my neighborhood. Yeah. Yeah.
Ms. O'Donnell?
The American Revolution began in 1775 as an open.
This person goes on to talk about taxation with and without representation, which is really great, but I am just going to skip ahead just a little bit just for the safety of time. I think she does a really great speech. If you do want to see what she says, this is the Canton Select Board 7/9/2024 on the not the history lesson. Yeah. Yeah. But I think the sentiment behind it is that you are your checkbook is full of our cash. You need to stand up for us, not for those guys that wear the vests and have the TV shows. You need to stand up for us. Really
in
good
the
sentiment,
colonies
but it
would be sent to England for trial. This meant that fewer witnesses and punishments handed down directly by colony judges. Over
heard a lot of
time,
people
with all
talk today.
colonial and dauntingly familiar. The right to a fair trial by jury of their peers was no longer possible to many. John Adams once frightens me most is even after what that would have convicted be corrupt and dirty.
And the
Thank you,
timer
Ms.
goes
O'Donnell.
off.
To those
Ms. O'Donnell, that's it.
who find our
Ms.
fight for
O'Donnell,
truth,
I'm going to ask you to
justice,
settle
and
down.
our American rights
I'm going to ask you to leave, Ms.
so
O'Donnell.
unacceptable to tonight. I
Officer.
quote Captain John.
She does only have 3 minutes, but this is what is happening. She does carry on over the 3 minutes. And I do the 3 minutes I think could have been used differently. I think she could have done a base of the history and then brought her concerns to the rest of the 2 minutes. But yeah, she does only have 3 minutes. But and like in that same vein, what do you mean we only have 3 minutes to talk to you? You have month after month after month after month of taxes from us. You can listen to us speak for how long. We're talking about the crimes that y'all have committed, not directly them per se, but those that they need to hold accountable for the crimes that they've like. We're talking about all of the bad things that they've done for so long. I'm going to go over my 3 minutes. And she stands her ground and tries to go over 3 minutes, and then all heck breaks loose.
And
Just
Paul
say how.
Jones, 1779. I have not begun to fight.
Thank you, Ms. O'Donnell.
I'm following the rules. We live in America, dude. Question on history.
Ms. O'Donnell, please.
Talking to me, but I will stay quiet. No need to leave. Exercising my First Amendment.
Ms. O'Donnell.
Okay, I'm going to speak. I'm going to speak now.
Ms. O'Donnell, you're being disruptive to the meeting. I'm asking you to leave. Thank you. Thank you.
I have nothing to leave for. I haven't broken any laws.
Oh, Jesus. Okay.
I'm answering you. I said I would stand here quietly. I will stand here quietly.
She only went over a few minutes, a minute. Okay, I'm going to, come on, will you, we're in crisis for crying out loud. I know it's my imagination. I know it's my imagination.
All right, folks, please be respectful. Ms. Lombardi, this is it.
Yes, thank you. Okay, listen, Rita Lombardi, and I can't believe I'm standing here about to say what I'm going to say. My ancestry goes back in this town to the very early 1900s, and I've always had respect for the Canton Police and the Fire Department because my ancestors served on them proudly, and I always admired them. And I'm shocked that I'm having this discussion right now. But anyways, the issues that we've had in town relate to safety and trust issues. And last week or whatever, you approved the police chief's contract, and many of us were opposed to that. And I just want to share some of the reasons why we have trust issues here. In 2000.
Okay, so they're talking about the police chief's renewal for a year. And this is, like I said, this in Lucky We Trust. This is a shirt showing the support for the humans that live in the town. Lucky, I don't remember my brain has pushed some of the trial things out. Lucky was the plow truck driver who testified under the defense's case. And in Lucky We Trust, you can see some of these green shirts there. Yes, they're wearing this shirt in support for the Karen Reed trial and the justice and the proctor being suspended and all that stuff. But she's not going to be directly talking about the Karen Reed case, like directly. She's talking about more things that go beyond it. And I think the Karen Reed case was a fantastic axe that was taken to the coconut of the dynamics here. That was a little better. That was a little better metaphor, right? So like the Karen Reed really broke a lot of this open, which I think is great. Shine a light on the corruption.
2018, the Canton Police Department responded to a car accident on Pleasant Street near Meadows, but did not locate the driver. An hour or so later, a passerby located the body of Craig Casey. This last year, when questioned by a concerned citizen, Chief Rafferty's response was, it wouldn't have made a difference to his survival.
It wouldn't have made a difference in his survival. Could you imagine being a family member and hearing that, and they just didn't, they were just like, can't find it. That's not the point.
Instead of owning this failure, that was her explanation. In 2021, the Canton Police Department ruled Sandra Birchmore's death a suicide. It was recently confirmed that Sandra was in fact murdered, something many citizens already knew. Yet there has been.
Raylene was talking to me about this case. This is a very sad case. Maybe one day I'll maybe like put a document together about it, and we'll talk about it, kind of staying in the realm of Massachusetts area. We'll talk about this case and maybe similarities, who's involved, and all that stuff. Break that case down.
There has been zero acknowledgement of this policing failure by Chief Rafferty or an apology to Sandra's family that I am aware of. In 2022, the Canton Police Department responded to the scene of Officer John O'Keefe's murder. The mishandling of the crime scene, the investigation, and the evidence collection was gross incompetence at best, and will be taught in criminal law classes for decades to come on how not to handle a murder crime scene. Instead of
probably not. I mean, yes, it will, like the other note, it will be laughed at, because this was it was laughable. It is the butt of all the jokes. So what do you mean we're not going to put it in a red Solo cup, fully open, and put it in a Stop and Shop paper bag and just hope for the best on the way home in a blizzard? Oh, you want me to Ziploc bag and Q-tip and the containers and all that stuff? You want me to wear gloves? It's going to be the butt of the jokes.
Instead of Chief Rafferty addressing these performance issues with appropriate corrective action, many, if not all involved, have been promoted. In any organization,
which is crazy. Can we listen to that again?
The investigation and the evidence collection was gross incompetence at best, and will be taught in criminal law classes for decades to come on how not to handle a murder crime scene. Instead of Chief Rafferty addressing these performance issues with appropriate corrective action, many, if not all involved, have been promoted.
Which is absolutely bonkers, because you're telling me the man with the leaf blower got promoted. Like, what do you... If I don't know exactly if the man with the leaf blower got promoted, but if there's an option for the man with the leaf blower to get promoted, that's crazy. We watched in a trial, a woman was facing a very, very up to life in prison. And we saw grown men with a leaf blower looking for taillight pieces. I mean, that's crazy. Like looking for blood evidence, looking for something. Give me something, right? And then, and then, and then they scooped it up. They scooped it up and put it in red Solo cups that they didn't even have. They went across the street, knocked on the door, and said, "Hey," I don't know if they might have called him or something, but let's just say that they walked across the street, knocked on the door, and said, "Hi, do you have any evidence containers?" And then the police officer who lived in that home said, "No, but I got to have a pack of red Solo cups." Like, what do you mean? Promoted?
In any organization, rewarding poor performance not only damages employee morale, it increases employee turnover, both of which are extremely costly. Canton PD has an 18
And also increases things like Karen Reed case happening. Like it also increases people being punished for crimes they have not committed, or people being found guilty on higher charges than they should have been. It also increases how many things can go wrong everywhere. It increases the possibility of death when it comes to interaction with police. It increases the possibility of charges while interacting with police. It increases the possibility of civil rights being stomped all over when interacting with police officers. You know, like these Canton police officers are giving me like, they're giving me the vibe of like, if you flip them off, they'll pull you over and give you a ticket, even though it's like a constitutionally protected right. You know, like it's giving, I don't care about your rights. I like my power. And patting those folks on the back is just going to perpetuate that and going to create a larger space for that activity to happen. It's called corruption.
15% turnover in the past 2 years. Oftentimes, it is your best employees who seek employment elsewhere, not the
And I don't want to say I have personal experience with that, but yes, in there was an incident that created discomfort between police officers in a town, and the police officers that disagreed with I'll say upper management and their decision to keep quiet and not press charges against someone against people who deserved charges pressed against them. The police who did not like that could not speak up. They weren't in a position to speak up and be heard, and so they left. Leaving that area to be handled and, protected and served with almost a handful of police officers. Not enough to fill out a full day's shift, a full 24-hour shift of police. Not enough to even train new police. So, yes, this is a problem. This is a real problem, and it create, oh god, it's just a never ending effect on, towns. And when it's spread knowledge that your police force is cut in a fraction of how many were on it, like if it's gone from 25 to 7, what happens? More people do more crimes because the chances of them getting caught is a lot slimmer. And then what happens when the crime rate rises? State police have to add a little more energy into that town, right? And what happens with state police? They go a little bit harder.
not the performance problem.
They're not local. They're not familiar with the community necessarily. You have a different local police, completely different vibe than state police, right? State police, they got jobs to do. Local police, you run into them at your local gas station, at your grocery store. You could have a conversation with someone about how these grapes are always gross at this grocery store, how you only come here to get your, you have like a higher probability of coming into contact with your local police in your local town than you do with state police. The vibe, the feel of the community is lost when you are now dealing with like upper echelon policing.
Problem. If unchecked, your organization will continue on a downward spiral. In the John O'Keefe murder trial, we learned that it was Chief Rafferty who turned over the Sallyport surveillance video to the Mass State Police. We also learned that in addition to 42 minutes missing from this footage and people disappearing from the screen, and the footage was inverted, something no one has ever heard of in their life. 6 weeks it took it to report the February accident, which almost cost the man his life. And now we're being sued for that. And we're going to get sued for all these other cases as well. Policies and procedures are great, but there's no consequences when they're not followed. Just rhetoric that we'll do better next time. That just doesn't cut it. The Canton Police Department and this town is facing countless and costly lawsuits as a result of their actions. We do not feel safe. And that is why. Okay, I'm not speaking for you because you're part of the selected few. I'm talking about me, common folks. I'm talking about me, the random citizen. That's who I'm talking about.
Thank you, Ms.
Anyone
Lombardi.
who's related to the McAlberts, you're safe, but not us.
Thank
So
you, Ms.
stop it.
Lombardi.
I'm sorry. Thank you.
Did you hear her? Anyone related to the McAlberts, which I think is not really right to be calling them that. They are in the McCabe's and Alberts. Let's just play it again. I'll just play it again. I'll just play it again for you. We'll just play it again because
Facing countless and costly lawsuits as a result of their actions. We do not feel safe. And that is why. Okay, I'm not speaking for you because you're part of the...
So someone says, not me. I feel perfectly fine here. If you have a problem with it, leave. That's the vibe, right? Ooh, living in a place where there's like people with a lot of money. there's the conversation happening of rent is too damn high, right? Rent's too damn high. Gas too damn high. Groceries are too damn high. Everything's too freaking expensive, right? And so when that gets taken to like neighborhood forums, you get handed well, if you can afford to live here, live somewhere else. It's like, okay, well, who do you want to make your coffee in the morning? Who do you want to bring your food to you when you go to a restaurant? Because if I move somewhere that's cheaper, I'm not going to come work here. I'm not going to then commute here. I'm going to go find a job in the area where it's cheaper to live. And so all the people that you're mad about not being able to afford to live in the town that they work, complaining because they can't afford to live in the town that they work in, you're telling them to leave. But then you're going to be upset when all those people who work in customer service, some sort of aspect, leave and there's no more little coffee shops to go to or little gift stores to go to or gas stations start closing because they don't have employees, or and big stores start closing and they don't have employees, right? So you're like, that's like the same energy that I just got. Well, not me. I feel safe. Okay, well, you're literally them. You are them. Of course you feel safe. You're them. You're blood or married in or something like that. That's what's happening here. You're them. I don't, because I'm not. Like, I'm not blood. I'm not married in. I wouldn't marry it. Like, like that's a crazy, I don't want to say crazy. That's a wild
The
thing.
selected few. I'm talking about.
This person is expressing her discomfort and her fear and her level of anxiety of living in a place that is running rampant with corruption. And she's being handed, okay, but why? Like, I'm not. You don't speak for all of us. No, I don't. But I speak for me and I speak for some of us, and I'm allowed to speak.
About me, common folks. I'm talking about me, the random citizen. That's who I'm talking about.
Thank you, Ms.
Anyone
Lombardi.
who's related to the McAlberts, you're safe, but not us.
Thank
So
you, Ms.
stop it.
Lombardi.
I'm sorry.
Thank you.
Thank you.
Running over here. She's getting yelled at and yelling. Can you see it right here?
Miss O'Donnell, you said you were going to be quiet. You got disruptive. It is time for you to leave. Miss O'Donnell, it is time for you to leave.
Wait, could someone cut that into a soundbite? Take your hands off me. That's
You are
great.
disruptive. It is time for you to leave. Ms. O'Donnell, it is time for you to leave.
That was a good soundbite. That was a good soundbite. So sorry. I got a little carried away with this one, but all right.
With members of the public out as many
To read. So, thank you, officer.
Okay, sorry, I just needed to find the time. So the public hearing is the public talk questions time is done in the Canton Select Board. Now they're moving on to other
All right, before we
Other
get on to the next agenda item, we have two statements to read. So, Mr. Albert, do you want to go first?
Yeah, I'll go first. Okay, as many of you know,
this is Kevin Albert speaking here.
I've
I
had two
believe
recent
Kevin, right?
verbal altercations with members of the public outside of my role as a select board. Despite the tremendous harassment, stress, and anxiety that my family, extended family, and I have been subjected to over the past 16 months, my interactions were inappropriate, and as an elected official, I am held to a higher standard.
Christopher Albert, not Kevin. My bad. I keep saying Kevin. There's so many.
And I understand that the residents of Canton expect public officials to always conduct themselves professionally and focus on the business of the town. I apologize for my recent reaction and will refrain from any further public incidents that I'm becoming as a member of this Canton Select Board. Thank you.
Thank you, Mr. Albert. An additional statement, Chief Rafferty has placed Kevin Albert on paid administrative leave while an outside, and please be quiet, while an outside independent investigation is being conducted relative to his actions in a case he investigated with Michael Proctor approximately 2 years ago. Kevin Albert was placed on leave on June 13th and will remain on leave until the results of the investigation are provided by the outside independent investigator.
All right, let's listen to that again because it rolled straight from Christopher Albert to Kevin Albert. So Christopher Albert said, hey, look, my bad. I got into a couple altercations verbally outside of my role here. And, you know, I'm supposed to be held to a higher standard. Yeah, so is literally, like, it's like the Alberts need to get it together. Okay, so let's listen to this one again. This is an announcement about Kevin Albert.
An additional statement.
Kevin Albert is a Canton PD officer, not a Boston PD.
Chief Rafferty has placed Kevin Albert on paid administrative leave while an outside
Paid administrative leave. Taxpayer money is still going into his bank account, but he is not working.
And please be quiet. While an outside independent investigation is being conducted relative to his actions in a case he investigated with Michael Proctor approximately 2 years ago. Kevin.
That's the one where they were on the Cape and they got super drunk. And then there's the text messages. I'm so hungover, my guy. I'm so hungover, bro. Sif. I don't know. I don't know how they talk. I don't know how he sounds. But it's probably like, I'm so hungover and I lost my gun and badge. Whoopsie doodles. No biggie. If you find it, call me. Like, and that's just the top, you know, that's not everything. And there are investigators will investigate this investigation. And
Kevin Albert was placed on leave on June 13th and will remain on leave until the results of the investigation are provided by the outside independent investigator.
June 13th, Kevin Albert was placed on leave June 13th. This is from July 9th, and we are just finding that out. June 13th, a day after Proctor testified, Kevin Albert was put on administrative leave.
All right.
All right, first on the agenda for tonight, Mr. Scollins and Mr. Lynch, want to step forward? Oh,
So that was like groundbreaking. That was crazy. That was crazy. So we have all of this happening within a week, except for Kevin Albert, but like we found out about it, right? Let me take this out and let me close this and let's just talk and wrap it up. So we have the first juror to reach out. We have informant B and C to reach out on behalf, kind of. I don't want to say on behalf because we don't know if the juror wanted them to send information along to Yannetti. And then so we had the motion to dismiss. And then we had the motion to impound all of the juror information. We had Michael Proctor put on administrative leave and then suspended without pay, and internal affairs investigation, federal investigation. We had juror number 4 come out. Well, I'm going to say technically juror number 2, but we'll just say juror D come out and say, put me in, coach, put me in. I will raise my right hand and put my other one on a bibble, and I will tell you exactly what went down. And we just didn't know what the hell to do, and no one told us what to do in a way where we understood what to do. And then we had Proctor. No, we talked about Proctor, Kevin Albert, the meeting. There is tension in Canton. Aidan Kearney, I think, has a hearing or just had a hearing. There are claims of, there's witness intimidation and federal investigation and it's like this is wild. This is wild. All the things that are happening. Absolutely wild. And the only thing that I know for sure at the end of this trial is that January 28th into January 29th of 2022, it was snowing, and then something happened. And I believe in my heart of hearts that Karen Reed did not kill John O'Keefe. That's really it. That's really all that, like, we kind of, and the corruption, and cops are corrupt. But, wow. That was a lot for a small town murder case. And it's not over. The affidavits are not over. The 22nd, there will be a hearing. It was supposed to talk about planning trial number 2. It was supposed to cover, okay, we've had a mistrial. Now what? The DA very quickly, moments after the mistrial was declared, came out and said, we are going to retry Karen Reed. Absolutely. They did not wait until the 22nd. They immediately said that out loud. Mr. Jackson, Mr. Yannetti, they said, we're not going anywhere. I mean, Mr. Jackson went back to California, but he's still on board. So everything is up in the air. Before they can even start planning another trial, they have to sort all this juror mess out. And they have the opportunity to. They can do it. It's not out of the question. It's not written in stone. There can be amendments made. And if they did find Karen not guilty on counts 1 and 3, would the DA retry it on count 2. That seems like a lot for that. And I don't want to like diminish a manslaughter count. But a second trial for I don't know. We'll see. I'll keep you updated. I'll keep you up to date on all the things that are happening with it. And that's all the things. That's all the things. We talked about all the things. I don't know if there's any other things that we could possibly talk about from the Karen Reed. I did want to like hop into the Alec Baldwin thing, but that's not happening today. Nope. That's not happening today. So I guess I will play I guess I'll just play my intro on the way out and then that'll be it. And then I guess I don't know, I'll see you maybe tomorrow. Maybe we'll talk about something tomorrow. See what's going on. Maybe we'll pop into the Alec Baldwin trial and see what's happening, see how it's going, which I have a feeling that it's going not smoothly for the lawyers, at least, because there's a lot of rules that they need to abide by on that are out of the norm. So we'll see. Thanks for being here. Thanks for watching. This is the intro outro for today, and I will see you maybe tomorrow. Hopefully my camera, I got to work on this camera thing. That's so weird. Okay, bye. Bye. Have a good one. I'll see you next time.